All right.
Webinar is being.
Good morning, everybody. I'm calling the June meeting of the Tennessee Real Estate Commission to order. It is just past 8:30 in the morning, and we will begin with the public disclaimer and roll call by Ms. Baker. Ms. Baker, please.
Thank you. Notice of the June 2026 meeting of the Tennessee Real Estate Commission has been noticed on the Tennessee Real Estate Commission website since August 7th, 2025. Additionally, this month's agenda has been posted on the website since Wednesday, June 3rd, 2026. Individuals who wish to make a public comment on an item listed on the proposed agenda during the scheduled public comment period will need to sign in on the provided sign-in sheet or by placing their name in the chat box online. It is requested that comments be limited to 3 minutes out of respect for other speakers. I will now call the roll. Chair Diaz,
Here.
Vice Chair Smith,
Here.
Commissioner Moffitt, Commissioner Begley, Commissioner Torbett,
Here.
Commissioner Gwynn, Commissioner Gahn,
Here.
Commissioner Tucker, Commissioner Rampy. We have a quorum.
Thank you, Ms. Baker. We'll now do the prayer and pledge. To lead us in both will be Commissioner Smith. Commissioner Smith. Thank you, Commissioner Smith. Next is to adopt the agenda. Commissioners, we've reviewed the agenda. Are there any amendments?
There is an addendum to the consent agenda that has been presented that would need to be added to this current agenda.
And are those three new cases you sent to us?
Correct.
All right, commissioners received those 3 cases yesterday, received a hard copy this morning. Are there any other amendments to the agenda? Hearing none, is there a motion to adopt as amended? Have a motion to adopt the agenda as amended by Commissioner Gahn, seconded by Commissioner Smith. Any further discussion? Hearing none, all those in favor say aye. Any opposed? Hearing none, that motion carries unanimously. Now is the approval of the minutes. Commissioners received the minutes of April's meeting. Having reviewed those minutes, are there any amendments to those minutes? Hearing none, is there a motion to adopt? I have a motion by Commissioner Smith to adopt the minutes, seconded by Commissioner Gwynn. Any further discussion? Hearing none, all those in favor, please say aye. Any opposed? Motion carries unanimously. And just for the information, there are 8 commissioners present today, so any motion to pass requires 5 votes. Any motion where there's a tie, the motion fails. Okay, on to the informal appearances. Commissioner, Ms. Baker, do you want to do a roll call?
Yes, we have 5 candidates for informal appearances today. And allow us a moment as we get them into the room where you can see them. For those appearing for informal appearances, we request that you turn on your camera. Mr. Falke, I just want to confirm you are parked, correct? Okay. I'm going to briefly call the roll for informal appearances to make sure that all the candidates for informal appearances are present with their principal broker. First, we have Eric Falke, which I see. And first of all, if I mispronounce your name, I do apologize. I believe you are present. Next, we have Kenya Flemings. I believe you are present. Yes, I see you. Deshaun Whitaker with principal broker Jennifer Kavanaugh. Okay, I see Deshaun. Is your principal broker Jennifer here with us today? Yes, okay, thank you. Next, we have James Boatwright with principal broker Roger Sargent. Are you all here today? Thank you. Next, we have Brandon Parker with principal broker Hugh Ross Wenzel. Are you all present today?
Yes.
Thank you. Lastly, we have Haley Bernstein with principal broker Elizabeth Lamb. Okay, looks like everyone is present today. What we will do is I will read a brief synopsis of your situation, and if you've passed the exam and what type of license that you are requesting from the commission will then ask you questions, or you're able to make a statement, and then the commission will ask you questions of not only the applicant but the principal broker as well. So I'll get into applicant A if that's okay.
Go ahead.
All right. First, we have Mr. Falke with principal broker Kenya Flemings. Mr. Falke has taken and passed the national and state affiliate brokers exam. He appears before us today due to a theft charge. Chair Diaz.
Thank you, Ms. Baker. Mr. Falke, if you'd go ahead and turn your mic on and tell the commission briefly the circumstances that caused you to appear before us today.
Yes, sir. First, thanks to the commission for the time and for the meeting. To answer your question, the circumstances leading up to my events, I'm not going to downplay. I take full responsibility for everything that I've done in my past. I struggled with substance abuse, and in those situations, it put me into questionable life choices, and I resulted in some sticky situations where misdemeanors were involved. In that time, or since that time, I have done a full recovery. I've completed a 1-year transitional program. I was a house mentor of over 25 men. I was placed in a job situation where I've actually excelled. I was promoted twice within the 2 years that I've been here. And I think being here today states that this is a long road recovery and that I have taken serious steps to get here just to be in front of you guys today.
Thank you, Mr. Falke. And just so everybody knows, we've received materials from or submissions from each of these candidates that explain their situation. So commissioners, do we have any questions for this applicant? Hearing none, Ms. Plemons, would you like to speak in support of this applicant?
Well, I do believe in rehabilitation. I believe in people changing. I believe that people can certainly make mistakes in their past, and I'm willing to give him the ability to grow and excel as a Tennessee realtor at my brokerage. And I believe the steps that he's taken, that he has shared with me, are appropriate and exactly what he needs, as long as he continues in all of that, which he has said that he's still accountable. He is still with groups that, hold accountability. And so I think he may actually be a really good agent.
Thank you, Ms. Plemons. Mr. Falke, I did want to ask you, do you expect to work real estate full-time, part-time? What's your intention?
I do have a current position that I would need to transition out of, so I would be part-time. But I would like to make this a full career and give it a full effort.
Okay, and Ms. Plemons, the supervisory training aspect of your affiliation, how do you feel about that with Mr. Falke?
Yeah, that's a great question. Thank you. Company, I created a mentorship program, and every new affiliate has to go through it. So although he has another job, we do have a few other agents that have other jobs that they want to get out of. And so part of the mentorship that Eric has to go through, he is paired with a mentor. He is accountable to them on a weekly basis. He has to report into them as far as, whatever he does with a consumer has to be with the mentor. He is not solo, and that's on 2 buyer transactions and 2 sellers. He has to come to meetings at certain times of the month. So there's somewhat a lot of accountability for new agents that join my company simply because I can't have anybody out there unsupervised.
Right. So they'll be getting familiar with the paperwork, building a file,
Right.
that
They're
kind of
given
stuff.
homework. Yeah, the mentor gives,
Advertising.
yes, advertising. Yeah, all
Because
of that.
we see a lot of new affiliates get dinged on advertising, and so I'm glad
Yeah.
you're going to be covering that.
Yeah,
Commissioners, any
anything
more?
that he does, yeah, he has to run by me, and also, I will supervise it all. I'll supervise everything he does.
All right. Thank you so much. Commissioners, any other
Thank you.
questions for Mr. Falke? Ms. Falke, are we pronouncing your name correctly? Is it Falke or
It's
Falk?
very close. It's Falk. It's Falk. My dad would have said
Falk.
Falky.
Okay, Mr. Falk. Commissioners, any questions for either Mr. Falk or Ms. Plemons? Hearing none, is there a motion?
Motion to approve. Second.
I have a motion by Commissioner Tucker to approve this applicant, seconded by Commissioner Gahn. Any further discussion? Hearing none, all those in favor of the motion, please say aye. Any opposed? Hearing none, the motion carries. Congratulations, Mr. Falk, and good luck to you. You're welcome to stay and listen, or you can go ahead and go about your day.
Thank you
Thank
for
you,
your time,
everyone.
guys. Thank you.
Thank you.
Ms. Baker, candidate B.
Thank you. Candidate B is Mr. Deshaun Whitaker with Principal Broker Jennifer Nicole Kavanaugh. Mr. Whitaker has taken and passed the timeshare salesperson exam. He is before us today due to a theft charge. His statement and letter of recommendation can be found on your iPads.
All right, good morning, Mr. Whitaker. Why don't you go ahead and, you saw how it played out for the first applicant, so let's go ahead and tell the commission the circumstances that caused you to appear before us today.
Good morning. Just like to say thank you for the opportunity, everybody involved. And just quick on the things that happened. I was young. I lived in Chicago. I was surrounded myself with the wrong people, the wrong crowd, doing all the wrong things. And, I take full responsibility in everything that I did. And, I think I completely changed and did a 180. I've maintained employment since that time. I took all the right steps to, get these things removed from my criminal record, and it's just a arrest record as of now. I've maintained employment. I've gotten promotions at 2, 3 different jobs, and I changed my settings. I changed the people I hanged around with, and I just, like I said, did a complete 180 on all the things that I felt was weighing me down at the time and making me causing me to make those bad decisions.
Commissioners, any questions for Mr. Whitaker? Hearing none, Ms. Kavanaugh, if you'd like to speak in support of his candidacy.
Good morning. We've all appreciated the time and energy that Deshaun has put in with all of our training and our mentoring. Wonderful asset, beautiful attitude. We're excited to have him as part of our team.
So I'll ask you the same questions as the previous applicant. So the training and supervision aspects of your company, describe that to us, please.
We've already started through his training program, just a lot of the product knowledge piece, that advertising piece is all covered by the company. So he's worked diligently in the product knowledge. He has a manager in place that'll continue through his onboarding and his mentoring program. So he's got someone walking with him through the entire process. We have a management team in place. We have a quality assurance team in place that follows that as well.
Okay. Commissioners, any questions for Ms. Kavanaugh? Hearing none, is there a motion?
Motion to approve. Second.
Have a motion to approve by Commissioner Torbett, seconded by Commissioner Smith. Any further discussion? Hearing none, all those in favor, please say aye. Any opposed? Hearing none, that motion carries unanimously. Congratulations, Mr. Whitaker, and good luck to you.
Thank you so much. I appreciate it.
All right, have a good day. Ms. Baker,
You
Commissioner
too.
C.
Candidate Candidate C is James Boatwright, appearing with Principal Broker Roger Sargent. Mr. Boatwright has taken and passed the national and state affiliate broker exams. He appears before us today due to a felony in possession of a firearm. His statement and letter of recommendations can be found on the iPads.
All right, Mr. Boatwright, go ahead and make sure your mic's on and describe the circumstances that caused you to appear before us today.
Good morning, and thank you for your time this morning. You know, when I was younger, my father passed away, and when he passed away, I made a lot of mistakes, and I didn't want to leave college. I started selling marijuana, got in trouble for that, and years later, my mother had left me a firearm that was my father's, 22 rifle and a shotgun, and I got pulled over. And it was in my trunk. A police officer asked me about that, and I was completely honest. And so the judge had mercy on me and gave me probation. And that was 10 years ago. Completely changed my life. I've been active in my community. I go back to juvenile centers and speak to kids, explaining that the decisions that they make, how impactful they are on their lives. I've had my CDL for over 9 years at this point. Held that professional standard, constantly seeking for the next level of my life. And I believe that to be real estate. And I just look for the opportunity for my family. And I thank you guys for your time. And I appreciate your time.
All right, so Mr. Boatwright, the underlying felony wasn't part of the submission. I'm guessing that's because it was outside the 10-year window. But so you said that you got hit a felony for possession of marijuana?
I was selling marijuana when I was in college. And I got
You were
trouble
selling?
for that. Yeah, that
Okay.
was outside the window of the 10 years. That's correct.
Okay. All right. Commissioners, any other questions for Mr. Boatwright? Mr. Sargent, if you're in a place where you could turn your camera on and turn your mic on.
I've got my camera and my mic on. Can you hear me?
Oh, there you are. Okay. I was looking in the wrong spot. Thank you, sir. Mr. Sargent, go ahead and speak in support of his application, please.
Yes, sir. And thank you to all the commissioners for allowing me to speak to you this morning. I don't take lightly whenever I have had the opportunity to come before you for this or any other matter for that concern. Several things that I take into consideration when I meet with an applicant. First, what did they do? Secondly, how long ago was it? What have they done since? And last and most importantly to me is, do they take ownership and accountability for their mistakes? We all make mistakes, but I think how we respond when we make mistakes really defines who we are as a person and the quality of our character. I'm confident that Mr. Boatwright has taken full accountability for his mistakes. It's been a long time, and I can look at the things that he's done in his life since then. He comes recommended by other people that I know. So, I come here and I'm happy to come before you today and say that I would be more than happy to be his supervising broker. And we do, you had asked that one of the other brokers a few minutes ago, about how we support them. We've got a full mentorship program that we offer to new agents as well, whether they're full-time or dual career. I'll have provisions in place to make sure that he gets the support he needs. But as his broker, I'll stand before you and say that I'm confident we can help him, and I am confident that he does take accountability and responsibility for his past mistakes.
Mr. Sargent, if you could say how many other affiliates do you have that you're supervising?
Well, where I'm the managing broker, there's approximately 40 something agents there. I am the CEO and general manager of 5 of our locations. So indirectly, I supervise a lot more than that. But we've got close to about 245. across all locations.
Okay, so, but you personally are going to be his managing broker?
Yes, sir. I will personally be his managing broker.
Okay. Commissioners, any other questions for Mr. Sargent? Hearing none, is there a motion? I got a motion by Commissioner Wampy, seconded by Commissioner Moffett to approve this applicant.
Excuse me, I believe it's Commissioner Rampy.
Forgive me, Commissioner Rampy. And seconded by Commissioner Moffett. Any further discussion on the motion? Hearing none, all those in favor, please say aye.
Aye.
Any opposed? Hearing none, that motion carries unanimously. Congratulations, Mr. Boatwright, and good luck to you, sir.
Thank you, sir.
Thank you all.
Ms. Baker, candidate D.
Candidate D is Brandon Parker, appearing with Principal Broker Hugh Wenzel. Mr. Parker has taken and passed the national and state affiliate broker exams. He appears before us today due to a consent order in Illinois. His statement and letter of recommendation can be found on your iPads.
Okay, Mr. Parker, go ahead and describe the circumstances that caused you to appear before us today.
Thank you very much. Good morning, commissioners and staff. Appreciate you taking the time to meet with me this morning. Again, my name is Brandon Parker, and I've prepared a written statement just to outline my situation to make it as clear as possible. And I'll do that now. I've been a licensed property and casualty insurance agent in Tennessee since 1999. I've also, over the years, held many non-resident license in other states during that time. In 2010, while I was working at Acceptance Insurance, I was notified by the Indiana Department of Insurance regarding a missed quarterly tax filing. That matter resulted in a $1,000 fine and a 1-year license suspension of my insurance license. At that time, I misunderstood the situation, believed it to be more of a company issue rather than a matter tied to me personally as a licensee. Fast forward to 2018, while working at Mendota Insurance, where I currently serve as the Vice President of Sales and Marketing, I applied for a non-resident Illinois license. And during that application process, I answered the question incorrectly and failed to disclose the Indiana infraction previously. The Illinois DOI identified the oversight, imposed a $500 fine, and ultimately approved my license. I realized the mistake that I made, and I take full responsibility for it, obviously. Since then, I've made it a priority to be thorough and careful and intentional when completing any regulatory or licensing documentation. I understand the importance of full transparency, and I take that responsibility very seriously. That is why I'm here today, and I'm looking forward to the opportunity to join Mr. Wetzel's and Mr. Felt's firm. And I appreciate them being here with me today and appreciate the willingness of their support. While we have not known each other very long, I'm hopefully that my experience, my accountability, and the steps I've taken since these prior matters demonstrate my commitment to doing things properly and going forward. I respectfully ask for your consideration and sincerely appreciate your time today.
Thank you, sir. Commissioners, any questions? Mr. Parker. Okay. Mr. Wetzel, go ahead and give us a statement in support of his application.
Yes, thank you so much for the opportunity to speak today. We take matters of this situation very seriously. Brendan has been forthright and upfront with everything and takes full accountability for all the mistakes that he has made. He is highly recommended by several agents that I've spoken with, and we're very excited to have him a part of our firm. We will be having him in our mentorship program and having regular meetings with him monthly and working with him through this process. But I feel like he will be an excellent addition to our firm, and we're very excited for the possibility.
Thank you. So, Mr. Parker, do you reside in Tennessee right now, or are you in Indiana,
Yes,
Illinois?
yeah, I live
where are
in
you?
Nashville. Yeah, I'm a Nashville native, one of the very few.
Okay, and Mr. Wetzel, your firm is in Nashville as well?
Yes, sir. We're based in Nashville.
Okay, so supervision should be pretty easy then.
Yes, we have a good plan in place that we will be meeting pretty regularly.
Okay, very good. Commissioners, any questions for the applicant or his broker? Hearing none, is there a motion?
Motion to approve.
Second.
I have a motion by Commissioner Gwynn, seconded by Commissioner Tucker to approve this applicant. Any further discussion? Hearing none, all those in favor, please say aye. Any opposed? Hearing none, that motion carries unanimously. Good luck, Mr. Parker, and thank you.
Thank you.
Ms. Baker, candidate E.
Candidate E is Ms. Haley Bernenstein. Am I pronouncing your last name correctly?
It's Brisen.
Brisen.
Yes.
All right, very good. We have candidate E, Ms. Brisen. She is appearing with principal broker Leslie Lamb. Ms. Brisen has not taken the affiliate broker exams. She is before us today due to a felony vehicular assault. Her statement and letter of recommendation can be found on your iPads.
Thank you, Ms. Baker. Ms. Brisentine, go ahead, describe the circumstances that caused you to appear before us today.
Well, I'd like to start by saying thank you for allowing me to be heard today. I really appreciate that, and I thank you all for your time. I made a really poor decision. It was just a one-time thing. It was the very first time I'd ever had alcohol and driven, and I learned immediately why that is absolutely atrocious. And I've taken full responsibility for everything that happened. I carry the remorse from it, but I've strived to be a better person every day. I've been sober ever since. It's been 4 years since it happened, but I want to be the best version of myself that I possibly can. And I have taken care of all the legal requirements for me to be able to get to this point.
Okay. So are you still on probation for this, or have you completed your probation?
I will be done in September.
In September. Okay. Ms. Lamb, if you could turn your camera on and microphone on, please, and make a statement in support of this applicant.
Good morning, everyone.
Good morning.
We have Haley's husband as a realtor with us. Therefore, that's how we originally met, which has been last quarter of 25, I guess, when Shane became a member of our office and has done a wonderful job. Let me say that. Haley has always been with him and by his side. They have been mentored by one of our top agents since day one. Shane has, and Haley's been very astute with doing what she could do legally to help Shane. Their objective is to become a team and do that full time as their income and to provide for their family. We work with our new agents as they come in. We mentor them with making sure that we are watching how they're doing their paperwork. I look at and approve every listing, every purchase and sale, all documentation that they do. Then again, they were brought into our office by two of my top agents and have been receiving mentorship from both of them on a daily basis. Shane has actually partnered with one of our top agents. So I believe, and I'm almost certain that that's what they have in mind to do, is to become a team like the Meads are and work hand in hand with them. I have talked to Haley and Shane, both her husband, Haley mostly, and talked to her about what happened and her remorse. And I think she has grown tremendously from that situation. And we understand that things happen and we don't want to forget those, but we want to work to rise above that and learn from, our mistakes, which we all do, hopefully. But we're excited to have her come on and this team be created. and I think they'll do great. I hate that it's a situation that has happened, but I think we can move forward in a positive way and be a good asset to the office. We're a smaller office. We're about 26 agents and work tremendously well together. Everyone is very willing to help each other out and are available to answer questions, help in situations, but they are closely monitored, and I feel like they have a good future ahead of them. We're happy to have them.
Thank you, Ms. Lamb. Ms. Brizentine, in your submission, you talked about how you've been working with your husband on transactions that he has. How did you navigate the not crossing the border and going into unlicensed activity? Were questions asked of Ms. Lamb? Just describe that interaction, if you could, for us.
Just following the guidelines. I never overstepped or did anything that is, his requirements as far as like being an agent, but just about everything else. I mean, I've been present for showings and closings. I've gotten to see a lot, and I've gotten to witness us help a lot of people and a lot of lives be changed, and it's just inspired me to want to become an agent myself.
Thank you. Ms. Lamb, have they ever come to you with questions about, where the boundary is, if there's any gray area that they might have wandered into?
No, yes, they have, and they are very aware that there are some gray areas, several gray areas, and she has actually kind of just been I'm going to say rider and a observer during the time that Shane has been on board with us. And I think she's learned a lot just from, I'm going to say, sitting in the back seat and watching, listening, observing, going through the situations that you can run across. Each transaction is different, and she understands that there's a lot. She's got a lot to learn, and is willing to do that.
All right. Thank you, Ms. Lamb. Any other questions, commissioners? Hearing none, is there a motion?
Make a motion to approve.
I have a motion to approve this application from Commissioner Smith, seconded by Commissioner Gahn. Any further discussion? Hearing none, all those in favor of the motion, please say aye. Any opposed? Hearing none, that motion carries unanimously. Congratulations, Ms. Brizentine, and good luck.
Thank you.
Thank
you
you
so
very
much.
much.
Ms. Baker, Fresh Start applicants.
Thank you. As a reminder, the Fresh Start Act allows individuals to request an early review from Trec to determine whether their criminal history alone would disqualify them from obtaining a real estate license before completing the full application process. It does not lower licensing standards, but instead increases clarity and transparency by requiring written explanations when disqualification occurs. Overall, it provides applicants with a clearer guidance and a focused preliminary determination based solely on criminal history before moving forward. The first one we have is candidate A, Miss Teresa Wright. She is requesting an affiliate broker license. The list of her convictions are provided on your iPads for your review and consideration.
So on the summary of this applicant, there's a name of convictions. It's redacted partially, but there's gun possession, and then there's a comma, and it looks like it was cut off. Is there more to that submission than we were able to see right here?
One moment while we pull that information.
No.
No, so the one that's redacted is not something that you can review.
After that, it says gun possession, comma, two.
I know I looked at the documents. It's not, the ones that you're reviewing before you are going to be according to the charging documents, which is going to be the gun possession charge.
Okay. Thank you.
As a reminder, please remember to use your microphones.
Mr. Chairman,
Go ahead.
I'm going to recuse myself from this applicant.
Thank you, Commissioner Gwynn. So any motion for this applicant will require 4 votes to pass. What do we think, commissioners? In my notes, I asked, they serve their time in Mississippi. Do they reside? I just want to know where they reside. Are they in Tennessee, Mississippi, elsewhere? Do we know?
One moment while we attempt to pull that information. According to what has been submitted, they live in Mississippi.
Okay. Any other thoughts, commissioners?
So we're approving for them to take the exam. Is this correct?
You're allowing this person a path to licensure, and if their TBI comes back and
Has anything else in it?
then they would have to be represented. But if it's only what they disclose, they're allowed a license.
Okay. I'll make a motion we approve.
And obviously, they still have to meet all the other requirements. So the 60 hours of pre-licensing education, in addition to the 30-hour course for new affiliates. The TBI report also has to be submitted in addition to the $91 initial application fee.
Commissioner Gahn has made a motion to approve this applicant. Is there a second? Seconded by Commissioner Smith. Any further discussion? Hearing none, let's vote. All those in favor of the motion, please say aye. Any opposed? Hearing none, that motion carries on a 7-0 with 1 recusal by Commissioner Gwynn. That motion carries. Ms. Baker, candidate B for a fresh start.
Thank you. And I'm going to defer to Anna after I give you all a recap. Mr. Smith is reappearing to request his timeshare salesperson license. The commission failed to include pertinent information required in their discussion at the meeting in Knoxville. Therefore, the First Start Act predetermination will need to be reconsidered.
So the commission does not have to reconsider the decision. It's just that at the time of the meeting, you made the decision to deny the individual based on their past criminal convictions. And when we make a denial in the Fresh Start Act, there's additional information and different steps that we have to go through, and we did not go through those steps on the record. So I believe you have the information before you. And as long as the decision remains the same, what I'll do is I'll just walk the commission through the steps of the information we need to have to include on the record so we can send the denial to the individual. So what I did at this time is when I was looking at it, when we send a denial, we have to include a letter that lets them know that they've been denied. This is the reason why. There are certain factors that the commission has to determine when making a denial based on the Fresh Start Act. So I reached out to that person and said, hey, can be referred to the commission for reconsideration in June, or they had the ability to just appear in informal capacity with a potential principal broker for application purposes, and they could move forward with that. I didn't hear back from them. So just to be safe, what we're going to do is go ahead and send that denial letter, but we'll include the factors of why the commission made the denial. Are there any further questions based upon the information I provided you? Okay, so what I'll do is I'm going to read you some portions, then we'll need to have some discussion or reasoning why the commission has decided to make a denial on this applicant based upon that in response. And then what I'll do is after the meeting, go back, type up the information, send it to the applicant, and let them know. So in considering whether to deny an application for a license or whether to refuse a license on the basis of a criminal conviction, the licensing authority must consider. This is A. A is the relationship between the nature of the crime and the purposes for regulating the occupation.
So if memory serves, and the minutes, the discussion at the April meeting about this particular applicant was the number and nature of the crimes. We just, just speaking for me, I felt like this applicant has not, at this time with the submission, shown any sorry, I'm searching for the words. Any remorse or any change in behavior that would, where I would feel comfortable with them having a license, a real estate license.
So just for additional context, just so you all know, the primary conviction that was considered before the commission is going to be the aggravated assault charge for the individual, and he was sentenced to 5 years, and this was in 2023, and this person is on parole through August 2026, and it is a timeshare salesperson license. So that should be, if that jogs your memory back from what was related to it. There were some additional charges that went along with it, but the primary, what we'll be looking for is that felony aggravated assault charge. And then there was a felony vehicular assault matter. Those are the two charges that the individual had related to that. The second factor is going to be the relationship between the crime and the ability, capacity, and fitness required to perform the duties and discharge the responsibilities of the profession. So we're looking at relationship between crime and the ability, capacity, and fitness required to perform the duties of the occupation.
Because of the stage that this applicant's at, so we don't know which company he's going to be a timeshare salesperson with yet?
No. So it's a predetermination. Basically, it's the ability for individuals to, hey, I have this criminal history. Am I going to be able to get a license? It saves them, possibly additional money and time studying beforehand, because if it's disqualifying, why move forward with the process?
I've got a question.
Yes.
So I'm looking at a thing called pre-adverse action notification.
Okay.
It's a list of a bunch of crimes. It says you recently authorized Travel and Leisure Company to obtain consumer reports. So this was written to who?
So this was sent to the applicant. I believe what this is essentially is a form of a consumer background check that they can pull on themselves. And so it's redacted because it has their last name there. And so I believe Travel and Leisure Company, I don't think that's the actual name of it. I think that's just probably a placeholder, would be the timeshare company that they're attempting to work for.
Okay. So it's not like they were applying for something else and just used this form for this purpose.
It's possible that the Travel and Leisure Company is not the timeshare company. It's possible that it could be used for that, for another application purposes. It looks to me it's very standard, like similar to something that you can do like a credit report. We do these things called clear background checks on individuals, where we can pull a background check that includes their criminal history, credit information, previous addresses. So I believe that's what this document is. Just one of those all-encompassing things instead of actually going to get printed by the TBI because it's not required at this stage.
I have a question. So this document was prepared by, was sent to us by Mr. Smith, is that correct?
That's correct. All the documents we have were sent in from the applicant.
So looking at the minutes from April's meeting, Commissioner Smith, you made the motion to deny, and Commissioner Gwynn seconded it. So if you have any recollections about that conversation or reasonings, that'd be helpful.
And if you don't have specific recollections related from that, you can literally talk about it again right now.
I remember being struck by the number of crimes. I questioned Anna about the naming convention for the case numbers and wanted to know that if they had the same case number, those count as separate charges and separate crimes. And I think she can remind us what her response was in that. So I guess the suffixes, the last numbers, 286, 16, 68, et cetera, those case numbers, they're all separate cases or cases within.
So if we're looking at them grouped together, oftentimes what will happen is when an individual is arrested, they will be charged with several different varying criminal offenses. And during the process, before the person goes to trial, or if they decide to settle, several of those matters will either be reduced from a lesser charge or even dismissed. So what I believe that we have here, and this is also what happens a lot of times when we're reviewing criminal history reports, is we'll have a laundry list of offenses that the person has been charged with. The ones that we want to focus on are the ones where it says that the disposition is where they've been guilty. The other ones do not matter in the circumstance because they weren't essentially charged with that. So here we have a set of different charges for this individual that were in different groupings. So you can charge certain convictions, then you can come back with more. It just all depends on what the person ends up being convicted with.
And if you can spare us from having to read the documents thoroughly, do we know what he was ultimately convicted of or pleaded guilty to?
Yes, hold on a second, I'll find it. Yes, but I just want to double check on here. So it looks like felony conviction of, there was the aggravated assault, and there's also vehicular assault that we have felony convictions for. And then there's a conviction for a lower level drug crime. But it is the vehicular assault and the aggravated assault.
And the dates on that were?
On the dates that I have for those are going to be, I believe they're all in the case numbers are 2022. So I believe the actual conviction dates are going to be 2023.
Thank you. So just to be clear, you didn't hear anything back from this person?
Right. I didn't hear anything back from them, but that still doesn't necessarily mean that, like, we did tell them no. So we need to finish the process to just let them know why the answer is no. So I gave them the opportunity to allow this to happen, what we're doing right now, or, you know, essentially a redo. And they come here with a principal broker, and you guys would have the opportunity, because that was one of the things that you said is I would like to see this person in an informal capacity, be able to speak to them, talk to the principal broker. Those were the two different options, and I did not hear a reply back. So in order to complete the Fresh Start Act things, I need additional information to send them in the denial. So the factor that we were just discussing is talking about the crime and the ability, capacity, fitness required to perform the duties and discharge the responsibilities of the profession. How does aggravated assault have any kind of correlation or impact someone's ability, capacity, or fitness in order to be a real estate agent?
And is that the only crime that we can pivot on? Or
We're
can we-
talking about that in the vehicular assault. That's it. Those are the only two.
Okay.
Because those are the only two that I see that we have guilty convictions for.
When this person was notified, were they notified by registered mail? How did they just get a regular letter or an email? How were they notified their option, which would be?
I sent them an email,
Okay.
an email address that we have had correspondence with in the past. So it's not a random email address that I found.
But no response from the email.
I did not receive a response.
So I think Anna needs a statement from us to answer that question about the crimes and why we think the nature of the crime is going to affect their ability to carry out their duties as a licensee. So does anybody want to take a shot at it?
This strikes me as a violent person. We're talking about an assault, and without their presence and getting to know them and have somebody vouch for them the way we do in these other cases, I just find it hard to approve or change our decision. I'd like to, but based on this, I don't think it's appropriate. But I would invite them. I mean, I would be great. I would consider it wonderful if they were allowed to speak to us, but if they're not responding, I see no reason to change course.
So the violent aspect of their crimes is what given us pause for pre-approving their going forward.
Okay, and what does violence have to do with being a real estate agent? Like, why would you think that would be a concern for that person being a real estate agent?
Well, I would say, having been in timeshare presentations, the agents doing the timeshare presentations are in a small conference room, and it has the possibility of getting a little tense in there, just because of the nature of the tactics that are employed by timeshare salesperson. And I just think an escalation could be possible. And I wouldn't want to put a consumer in a small room with this licensee.
Okay. Any additional comments? All right. The next one is going to be any evidence of rehabilitation or treatment undertaken by the individual that might mitigate against the relationship of crime to the occupation, profession, business, and trade. So in reviewing this individual's report, I did not see any information. Sorry, I have the wrong one. In the past, we've seen individuals that talked about different courses that they've taken that maybe has assisted in what is going in the crime or conviction. And looking in the information provided on the application, I don't see any narrative or information from Mr. Smith that talks about rehabilitation. So
I don't see it either.
So that can be, if we're discussing that, those are things to consider But I'm going to say, based upon those considerations, if you agree, the commission agrees that we don't have evidence of that information provided to us.
I agree with that
Unless
today.
anyone says that. Okay. And then the last one is going to be any applicable federal laws regarding an individual's participation in the profession, and there aren't any applicable federal laws that we have to do. So that would conclude the conversation unless there's anything else that the commission wants to say related to it about why the individual is denied. So what will happen now is I'm going to essentially summarize what we've had in this conversation, put it in a letter format. I'll also link the video so they can come back and watch it, link both of them so they can look at both of them, and then send the letter. And then at that point, the individual has appeal rights that are available to them if they would like to do that. And then, of course, there is also still the option if that person wants to apply to and then come in an informal appearance capacity. So I'll provide all of that information to them. Any other questions?
I have a question. I have a question.
Yes.
When you say letter, does that mean email and?
Yes, I'll
physical
put it
letter?
also in the mail.
So 2 forms
Yes.
of information to that person,
Yes.
email and paper.
Mm-hmm.
Okay, thank you.
I'll make sure that it's mailed out. I didn't send a mailing because individuals are not typically responsive to mailing. And since they had been communicative with the emails and it was something I needed a fast answer from, I thought email was best. But in these circumstances, I will send an email and a letter. In the future, if this happens, we'll just, so it's not bifurcated like this. We'll go, if we ever deny someone, it'll be directly after the conversation. But this one was essentially an error on my part that I'm trying to correct. Okay, thank you.
Question.
Yes.
Commissioner White.
You mentioned I'm back to this list, a lower level drug offense. And I'm just curious what that means because I'm looking at this and it says 10 pounds of marijuana hash. So I don't know if that's low level or not. I mean, I don't even know what a Schedule 6 drug is, but it looks pretty significant to me. But I just want your opinion of that. And if some of these
usually
other
what happens-
crimes have to do with a person maybe being a drug dealer, I don't know.
So usually what happens in the drug convictions is you'll be presented a range. So in this particular instance, it says Schedule 4 drugs, 1/2 ounce up to 10 pounds. We don't have the actual amount of what it is. And it is a Class E felony, which is the lowest level felony. And one of the reasons I called it a lower level drug crime is because in the ranges and schedules of drugs, marijuana is considered to be one of the lower level drug crimes, as opposed to, some of the more other drugs, cocaine, methamphetamine, those types.
So that's just a range of
Yes,
what's
so that's
going
how
on.
we categorize something.
So you don't really know what exactly it was.
No,
Okay.
but it determines the severity is based upon the amount that the individual was found with.
So
So if it was
just out of
more-
curiosity, what's the number one?
I have no idea.
Okay.
I don't know.
Commissioners, any other further questions about Fresh Start applications? All right, moving on to waiver requests. Commissioner, Ms. Baker.
Thank you all for your patience with the Fresh Start Act applications. This is new to all of us in some capacity, so thank you for your patience as we work out processes for that. Next, we have waiver requests. Our first waiver request is candidate A, Gina Lawson. Ms. Lawson's license expired February 23rd, 2025. She is requesting a medical waiver of late fees and retesting. Her statement can be found on the iPads.
I'm going to recuse myself from this.
Okay. Commissioner Torbett is recusing herself from this application request, waiver request, so any motion will require 4 votes to pass. So she wants to relief from the fees and retesting is what she's asking for.
That is correct. It should be noted that she has not taken any continuing education as well.
And the 1 year grace is expired. That's why she's got the $1,100 fee.
Yes.
So commissioners, when I was reading this, my first instinct was to relieve the fees and have her take the trace course. In my mind, the education is more important than the fee. But I'd be interested to hear other opinions.
That was my thought exactly. I don't know if that can be a motion, but that's exactly what I would propose. I'd like to make that motion.
Second.
All right, I got a motion by Commissioner Rampy to offer this waiver request to waive the fee and to require that she take the trace course. Do you want to put a clock on it?
Yeah, I understand. That's okay.
So trace is 30 hours. What do we typically do? 6 months?
6 months.
Yes, please remember to use your microphone.
Within 6 months.
So Commissioner Rampy makes the motion to waive the fee of $1,100 and to require Ms. Lawson to take the trace course within 180 days. You want it to count towards CE? Is that do we have to say yes or no?
Keep in mind, she didn't take any CE during her last licensing cycle. No CE was taken.
So if she takes trace, then she still has to do her continuing education if we don't let it count.
I would hope that she would have to do 16 hours of continuing education to include the core course as well.
Yes, not to be included in continuing education.
So I'll say the motion one more time in its entirety. Commissioner Rampy makes the motion to waive the $1,100 fee and to require Ms. Lawson to complete the trace course within 180 days, and it does not count towards her continuing education. And that was seconded by, remind me who seconded it, Commissioner Tucker. Any further discussion on this medical waiver request? Hearing none, let's vote. All those in favor of the motion, please say aye. Any opposed? Hearing none, the motion carries on a 7 yes, 0 no, 1 recusal of Commissioner Torbett. Motion carries. Candidate B, Ms. Baker.
Candidate B is Deborah Butts. Ms. Butts' license expired May 2nd, 2026. She has submitted a medical waiver request for a late fee of $100. She has not completed CE. Her statement can be found on the iPads. So her license just expired last month.
Did Ms. Butts say to you or to anybody that she's able to work now? Or is that the implication?
The only thing that we have is the statement that she provided on May 27th.
Okay, so we're left to imply that she's now able to work?
Correct.
I make a motion to accept the request to waive the $100 late fee.
Second.
Okay, do you want to put a clock on her for her to complete her CE?
And to complete the CE within,
So she's got to,
I get it, but I'm just thinking 6 months is too long. That's what I'm thinking.
Take in mind, when someone's license expires, there's a penalty for every 30 days. So
she needs to do it within 30 days.
Okay, very good.
all right, so the motion by Commissioner Smith is to waive the fee of $100 to this applicant and to require her to complete her 16 hours of continuing education within 30 days.
30 days of when?
Of acceptance of the offer, I guess, when she accepts.
Or when we mail the letter
When
to
you mail
her.
a letter.
Yeah.
So that motion by Commissioner Smith was seconded by Commissioner Orbit. Any further discussion? Hearing none, all those in favor of the motion, please say aye. Any opposed? Hearing none, that motion carries unanimously. Ms. Baker, candidate C.
Candidate C is Miss Brandon. Her license expired August 19th, 2025, so a little less than a year. She is seeking a medical waiver request in the amount of $800 in late fees. She has not completed the required 16 hours of continuing education. Her statement can be found on the iPads.
Yeah, so here's another one where my instinct was to waive the fee and require to complete the education. Again, putting a clock of 30 days on it. How do you guys feel about it?
Are you suggesting waive the fee, continue to the continuing education within 30 days? And is that the only education that you're asking?
Well, she had,
Well,
so
she-
parenthetically, you say a 6-hour course, so she completed the core? Or
Yes, she needs 12 additional hours,
So she needs 12 additional hours,
including the core course.
including the core. Okay.
Including the
So she
core
hasn't
course.
completed core.
Correct. She's
Okay.
taken 4 hours. So she now needs 4 hours, she has taken 4 hours. She now needs 12 hours, including the core course.
Okay. I'll make a motion to waive the fee, complete the 12-hour education within 30 days.
I got a motion by Commissioner Smith to waive the $800 fee for Ms. Brandon and require that she complete her 12 hours of continuing education within 30 days.
And that 12, just for clarification, that 12 hours of CE includes the core course, correct?
That is correct.
Okay. So we're going to waive the fee and we're going to have her complete 12 hours of continuing education, 6 of which will be the core course, and to be done within 30 days. And that was seconded by Commissioner Moffitt. Any further discussion on the motion? Hearing none, all those in favor, please say aye. Any opposed? Hearing none, that motion carries unanimously. Thank you, Commissioners. Next item on the agenda is the education report. Ms. Brittany.
Good morning, Commissioners. I'm excited to be presenting the education report to y'all today. On pages 1 through 7, you'll find the 24 candidates labeled JI-01 through JI-24 who have applied to be certified Trec instructors. The individuals presented today have met the qualification for instructors listed in Trec Rule 1260-05-.04.
Okay, Commissioners, you have the list of instructor applicants, JI-1 through JI-24. Are there any applicants you would like to pull for discussion? Hearing none, is there a motion to approve?
So moved.
I have a motion by Commissioner Smith to approve applicants JI-1 through JI-24, seconded by Commissioner Moffitt. Any further discussion? Hearing none, all those in favor, please say aye. Any opposed? Hearing none, that motion carries unanimously. Ms. Morris, the courses, please.
Next, on pages 8 through 17, you'll find the total of 46 courses labeled J1 through J46 that providers have applied for your approval to offer continuing education credit hours to licensees. All courses presented today have met the requirements set forth by Trec Rule 1260-05-.03, and each course has been assigned to one of the 17 subject categories as mentioned in Trec Rule 1260-05-.03 5A.
Commissioners, you have before you courses J1 through J46. Are there any courses that a commissioner would like to pull to discuss? Hearing none, is there a motion to approve?
Motion to approve. Second.
I have a motion by Commissioner Tucker to approve courses J1 through J46, seconded by Commissioner Smith. All those in favor of the motion, please say aye.
Aye.
Any opposed? Hearing none, that motion carries unanimously. Ms. Morris, Trek training overview.
Yes. Well, I also wanted to mention on the education report on pages 18 through 33, you'll find the PSI reports for April and May for the pass-fail rates for our state and national exams. Lastly, we do have the fiscal year 2026 Trek training overview memo that is included today. In 2026, fiscal year 2026, Trec staff embarked on a mission to create more outreach opportunities with licensees across the state. We're happy to say that we conducted 6 events in partnership with the State Fire Marshal's Office, the Rice Insurance Services Center, and local associations to help educate and get in front of 277 individual licensees and to create an opportunity to give them free CE hours to those who signed up and attended these courses, which we're so happy that Commissioner Smith did attend one of our courses in Jackson. And we are looking forward to continuing this education embarkment in the fiscal year 27 with 3 more events, course offerings happening before the end of this year.
Thank you so much. Ms. Morris, do you have any other parts of your report?
Nope, that concludes my report.
Commissioner Smith.
I have a question, and it may fall back on what we just discussed, but when we request these candidates to take education, trace, et cetera, I'm assuming we wait until we get their certificate that they've actually taken that additional education in that period of time. Is that correct?
Yes.
I'm just curious, do all of them follow through, or do you have some that fall through the crack and they don't do it?
It depends on the candidate. Okay. Or the applicant or the licensee or the formal licensee. It runs the gamut.
So the process would be just like if we said, take this continuing education, have it done in 30 days. And if you don't have a record of that, what happens then?
They default to previous options with the penalties imposed upon them.
Okay.
Because the commission's caveat was to take it within a certain amount of time.
Correct. Okay. Thank you. So is it a large majority that doesn't follow through, or can you really?
I would say for the most part, most follow through. It just really depends.
Okay. Thank you.
Ms. Baker, we'll count that as the beginning of your executive director report. Go ahead.
Very good. Thank you so much. You will find active licenses by professions and our complaints report, as well as financials on the iPads. If there are no questions about that, I do have a few updates for everyone. Are there any questions about the reports written on the iPads? All right, so let's first start with the Real Estate Educators Association Conference. Trec's Director of Education, Brittany, and I will be attending the RIA conference in July to prepare for recommendations for updates to the Trec's Core 27-28 course. In addition to current topics included in the 25-26 course, we plan to present during August's meeting several proposed revisions. These updates will address the distinction between association and club membership versus Trec's role as a regulatory body, the inclusion of appropriate disclosures as they relate to advertising, clarification of dual agency and broker supervision requirements, and updates to reinstatement pathways to ensure clarity and consistency. Our plan is to recommend transitioning from a commercial and residential core course to one single unified core course to better streamline content delivery and ensure consistent regulatory education for all licensees. Are there any questions in reference to that? Okay, very good. Next, I will provide an update in reference to the Arello conference in September. As you all are aware, the Arello conference in September is rapidly approaching. The request has been submitted on behalf of Trec for approval of travel to Arello in September with 3 Trec staff members, as well as Commissioner Rampey and Vice Chair Smith also participating in Commissioners College 101. Members of TDCI's leadership team have identified the individuals who should represent the commission. However, the request still needs final approval from the full TDCI executive leadership team, in addition to the State of Tennessee's Department of Finance and Administration. They must also approve the request before travel can be authorized. Attendance at this conference provides critical regulatory education, courses, and sessions, as well as national collaboration and committee engagement that directly support Tennessee's real estate regulatory framework. Are there any questions in reference to the conference in September? All right, very good. You will find on your iPads a letter from a licensee in reference to a possible rule change. As you know, there is a process to rule change, which Anna can go over if you would like. And if you have questions to staff in reference to this rule change, we have a point of view if you all would like to hear it.
Yeah, go ahead and tell us your point of view.
Okay. We wouldn't necessarily support this proposed type of amendment, and I would like to briefly explain why. We have concerns. Trec wants to maintain the integrity, independence, and public trust associated with required continuing education for Tennessee licensees. First, the existing rules provides a very clear and objective boundary between mandatory education and brokerage business activities. This standard was put into place to prevent any actual or perceived advantage for a particular brokerage when hosting required education. Even in situations where recruiting does not occur, brokerages often are naturally designed to promote the firm's brand, culture, and professional opportunities. Holding required education inside those spaces could create an appearance of an endorsement or an unfair competitive benefit. Second, allowing courses in brokerage facilities would introduce standards that are highly subjective and challenging to enforce. Staff would be required to evaluate whether the advertising was sufficient, whether all licensees had meaningful access, and whether any recruiting was done during the course itself. These are not conditions that can be monitored objectively or across the state, and inconsistent enforcement risk may occur, undermining public confidence in Trec's continuing education rules. Third, the proposed of the continuing education is to ensure competency and consumer protection, not to create opportunities for business development, preserving a clear separation between continuing education and broker operations that supports Trec's mission. Finally, the current rule has been in place for many years and is well understood by not only Trec instructors, Trec providers, and licensees. Removing or weakening the rule would increase administrative burden, introduce ambiguity, and potentially compromise the perception of independence that is essential to the continuing education process. For these reasons, Trec staff believes that the current rule remains to protect the public interest and to ensure uniform and partial oversight. Therefore, staff does not recommend adopting this proposed change in a rule-making hearing or session, rather. Are there any questions?
Commissioners, do we want to make any statements or express any thoughts?
I have one question.
Yes, sir.
I understand the recruiting possibility, and there's a word for it, and it's not coming to my mind. Bias, maybe. But would that still exist if the class was actually closed, where the principal broker or the owner of the firm could hire an instructor to come in and only teach their agents?
Well, we want continuing education opportunities open for everyone, and having a continuing education session at a brokerage opens up many opportunities for untruths. For example, steering could occur. In addition to steering, mistruths about reporting could possibly occur as well. And if it's in-house, there's no way for us to have those checks and balances to ensure that because the course probably wouldn't be advertised. There are courses that, especially online courses, that Trec team members just pop up and listen to make sure that they are adhering to the guidelines set forth in our education rules.
Understood.
And Trec team members have also audited several courses throughout the area as well. We just pop in. We don't necessarily tell them we're coming, but we do that probably 2 or 3 times a month with continuing education courses that are virtual.
Okay. Ms. Morris, are you able to tell us how many courses are asynchronous or virtual versus in person?
I don't have an exact number because those courses that are approved by y'all to be offered in a classroom setting can also be offered asynchronously, but they just go through an additional step of notifying us when that happens. They are required to send an email to trec.education@tn.gov, which I monitor, within 5 days prior to hosting this asynchronous course. They have to let us know what the course is, who the provider is, who the instructor is, who will be the monitor additional to that as well, because someone has to make sure all attendees are visible on camera at all times in order to maintain credit. That is within our rule of asynchronous distance education courses, what time, and then also provide us with a link. And as Director Baker mentioned, we do keep track of all this. We do have a running sheet that it has access to Trec staff that Director Baker and I do often pop in just to verify that they're doing things that they're supposed to be doing in the asynchronous format. I myself has also officially audited some in-person courses as well, and we'll continue to do so. And we're looking at ways to ramp up that audit process by utilizing additional Trec staff, because I am a team of one.
So to follow up in, you don't know approximately what percentage of hours are taken online versus live in, because when, I mean, I get her letter, I mean, goes back to 1980 or 86, and there was no online courses then. So as time has gone on, they're becoming, I would guess, more popular. So I'm wondering, why she doesn't move to, I mean, I don't know exactly how it works, but I would think the popularity of online is going to continue and require less live classes. Am I wrong on that, or?
There are approximately 760 courses that Trec has approved, so many of which are online, many of which are in person. And if the person goes through the proper approval process, they're able to teach that course online as well.
So they don't need a space to teach an online course, right?
The online courses that I have attended, all the participants, I've seen it several ways. I've seen them, all the participants are on camera at the same time. I've also seen situations in which an instructor is in the room with people sitting in front of his computer or her computer, and then also teaching online as well. So we've seen a plethora of different types of scenarios as it pertains to continuing education here in the state.
So if a person is teaching, they could use their house as a production location,
Yes.
right? With cameras and all that, and
I've seen
dial in, and so they don't need to really
I've seen some very snazzy setups. Yes, sir.
Okay.
Any other questions or comments?
Lastly, as far as my comments are concerned, Trec has updated and posted online its new Trec instructor form, and we will be updating many of its forms to comply with ADA guidelines, as well as new statutory changes that go into effect July 1st, 2026. The forms that will be changed as of July 1st are the Trec 2 form, the Vacation Lodging Service form, and the branch name change application. And Anna momentarily will review the updates as far as it goes for the word escapes me at the moment, the legislative update.
So,
And if there are no other questions, that concludes my report.
so you don't need for us to have a motion to not proceed with Ms. Pearson's?
Correct.
Okay. I thank Ms. Pearson for her submission. Thank you. Ms. Matlock, let's do the public comment. Public comment period is open. Ms. Baker, is there anybody signed up to? Public comments. Public comments.
One moment, I see one message online. No, I don't see any.
And we have somebody in the. So who's keeping time? We got 3 minutes.
One moment as I pull up our time. Just another second, please. All right. Ma'am, if you will begin by stating your name, and you have 3 minutes.
Good morning, everybody. My name is Kayla Pearson, and I'm the person who wrote the letter that you were just discussing. I'm a principal broker, a licensed instructor, and a certified TREF instructor for the Tennessee Realtors. The reason for the request was because as an instructor, we are finding that we're needing more in-house participation from our agents. We're starting to see a decline in the agent participation because they're finding that when they go online, they have options such as the CE Shop, Kaplan, and other online services that they can not be in front of the camera. In some places, they're utilizing an assistant or an AI service to complete their CE credits. So the request is to have the students come back into the classroom so we can get FaceTime with the students. But also, you often have a lot more collaboration and conversation when you're face to face rather than on a computer. It also gives the instructor the opportunity to have group sessions where they can do case studies together. And teaching a course online is very difficult to put together in relation to that of when you're in a classroom. You can do breakout sessions on a Zoom call, yes, but a lot of times when you break them out, you're not monitoring each group individually to see if they're just sitting there the entire time. Whereas in a classroom, you have the opportunity to see if the groups are collaborating with each other, if they're coming to a conclusion on those case studies. And it also gives you an opportunity to have the students share their case study findings to the entire group. The request for the courses to be held in a brokerage office is mainly because the brokerage offices, as we've evolved over the last 40 years, have included this space in their brokerage houses, whether it's in a co-working space, much like this facility, or maybe the brokerage is in one suite and another suite is that open space that it can be utilized by all tenants. Unfortunately, we're not able to host classes in those spaces. And so we're having to find off-site locations to host those classes. And those are going to be on the broker to pay for, or in fact, it gets passed on to the licensee to pay for with an increased cost for their continuing education, which is now leading them to just go online through the CE Shop because they can just buy a bundle course and have somebody do it for them without somebody actually checking to make sure that they're doing the coursework. And that is all my findings, and I hope that you guys reconsider the amendment and that we can move forward with some changes and get the students back in the classroom so we can get FaceTime once again past COVID pandemic.
Thank you, Ms. Pearson, for attending today. We know you didn't have to do that, so thank you so much for that. Is there anybody else that would like to seek time for the public comment period? Seeing none, I'll declare the public comment period closed. I'm interested if staff could try to figure out, she mentioned something about AI bots and people.
If there was an instance of someone not properly completing their continuing education, if a complaint was filed, we would investigate the matter and it would be brought to you all for disciplinary action to for that licensee not completing the required continuing education.
And what about the statement about providers not requiring FaceTime on cameras for asynchronous?
On all the asynchronous, correct. Well, asynchronous, yes, but for synchronous courses, all the courses that I have audited, with the exception of one, everyone was on camera the duration of the course. And if the person was not on camera, I would ask the person who was moderating the course if this person is going to receive credit, and they do not, because they weren't on camera and present for the duration of the course. Now, there are instances where someone may disappear for a moment or two, but for the most part, everyone is on the course for the entire time. And they also know, the instructors and providers, that if someone is driving while taking the course, that person should not receive credit for the course as well. I've seen an instance of that.
So I go back to what you said earlier, that if there are examples or instances where the course is not presented in compliance in a compliant way,
could be filed, the matter investigated, and it would be brought to you all to make a decision as to whether or not that person should receive disciplinary action or be issued a civil penalty for attesting to something that they did not do.
Okay.
Also, many providers are very keen on on emerging technology. And so there's systems also in place that hopefully prevents that. And Brittany and I will also learn more about that in July once we attend the conference with the Real Estate Education Association.
Okay.
If I may,
Go ahead.
I want to express respect for staff's wishes on this, and I see the need for all of that. But I also understand Ms. Pearson's intent. And I can see, I'm splitting hairs here, but imagine if the course was instructed by somebody online and everybody assembled in that company's training room, they would be accomplishing the same thing, would they not?
Not necessarily, no. Because the person is supposed to appear on camera during the duration of the course. And so what I have seen an instructor do is offer an in-classroom session, simultaneously offering a synchronous course session and doing both at the same time.
Well, I'm not concerned about whether they're getting away with not taking the course. I'm speaking to her request about amending this rule.
Mm-hmm.
And again, I'm seeing both sides, and I see a problem with no real solution. And I'm just using this example as it would be a complete workaround on their part that would be legal, would it not? It would not violate that law.
Continuing education as it stands now shouldn't be performed at any brokerage. Now, if a person were to take a course inside their brokerage, that's allowed. However, a live course at this time cannot be performed inside of a firm here in the state of Tennessee.
Understood.
So about the scenario that was presented where the brokerage is in a storefront and they have a suite that's separate from the brokerage, has its own door, et cetera, where they can host a course. Is there an opinion on that and how
Yes.
it complies with the law?
If it's the same building and they have adjoining doors that go in and out of each facility, we consider that the same facility.
So is the adjoining door, is that an internal door or is that an external?
Correct, it's an internal door.
Okay, so if it's two separate entries,
Mhm.
egress and digress, does that change the calculation in terms of complying with the law? Ms. Matlock, if you have an opinion also?
I'll give several opinions. The first opinion is that I do believe possibly when this rule was written, it was not contemplated the way that certain buildings are set up and the fact that we have suites and different buildings that are accessible. However, maybe it's not, maybe that is wrong in the fact that, let's take, for example, the signs requirement for the statute. In the statute, if you are located in an office building, you are not required to have that outside sign if you're working in a shared office space. So it's possible that's there. So I don't know if there was necessarily thinking about suites in different spaces. I think the adjoining door is something that's important because you're going back and forth. So one of the reasons that I've always understood this rule to mean is that individuals will be like, hey, you are looking for a brokerage, just come over with me to my office, through the adjoining door. But if it's in a completely, I think, different location, different suite number, different address, then we're looking at different spaces, I think. I will say this about the general schematics. The way that continuing education is set forth right now is probably going to be the standard moving forward. I don't see us going backwards to only requiring classes in the classroom. The reason I say that is one of my previous boards and commissions had a requirement where you had to take a certain percentage of your CE classes in the classroom, and then you could take the rest online. That was removed but I think it would be very difficult for us to get a rule passed or moved forward that requires people to physically be in the classroom, just because it's going to be hard to tell them with the creation of technology, actually, no, you have to physically go to a space. Also, we think about individuals that live all over the country. Telling them that they physically have to come to a space in Tennessee is just not feasible. So I think that online is going to be something that's always going to be around. And if anything, we're moving forward. That's the trajectory that we're going in. I don't see it going backwards. I think if we were to move forward with a rule that requires persons to be in the classroom, it would be very difficult for that rule to not only get out of this building, but to be passed through the legislature, because that's just not the mindset, my understanding of where we are when it comes to education and regulations. We want to make it accessible and easier for other individuals. And so that's why we tried to include those additional safeguards written in distance education to make sure those persons are paying attention. If there is ever an individual or a person that's aware of a company or a specific class or a course instructor that is not following those rules, then we need to know those things so we can audit those classes, make decisions from those classes, whether that person needs to be allowed to keep doing that. We don't have reports of that happening. So unless I get reports, unless I get firm details of information, to me, these are just hypothetical situations that I cannot act on. So if that's the case, then we need to know. I know there are issues with people not wanting to report persons, but if we're going to make it an equal playing field for everyone, I can't act on things that I don't know about.
Yeah, you need evidence.
I need evidence.
Yeah.
That's my job. But no, we just need to know. We need to know those things, because if I didn't spend all that time for rules to not be, I'm just kidding. No, the rules are there for a reason, because we think that enhances the learning experience. But those are just my thoughts and opinions on the situation. We've had several conversations over the years where individuals have given us schematics of their offices to be like, hey, does this work? And we're like, I don't think so. There's like a door. And they're like, well, the door, I was like, the rule is pretty clear on what it says. And so unless that were to change by whatever form or fashion, I think that's what it looks like.
Okay. So this Educators Association conference you're going to, I'm guessing whatever nuggets that you gather from there that you think would be helpful, we'll hear about.
In August.
Are they going to have any kind of conversations about AI? And
there are sessions on AI as well. And then in August, you all will hopefully vote on a core course for 27 and 28. Can you believe that we're talking about 2027 and 2028? Blows my mind. So you all will be voting on what the outline should look like for instructors moving forward for the core course. As well as in August and early September, we'll be mailing all instructors and providers renewal applications as well, so they are able to renew their licenses for 27 and 28. We are in a renewal year, not only for instructors, but for courses as well. So we'll recertify every instructor in every course, and then instructors will also submit their applications for the new core course 27 and 28 between September and December of this year.
Okay. Thank you so much.
Can I make this?
Commissioner Gwynn, go ahead.
I'm kind of with Commissioner Rampy. I'm sympathetic to Ms. Pearson on this request. And I just think that it seems like we should have more information about what the stats say about who is going to class and who isn't. If you added up all the hours that have to be taken in the state per year, how many people are going live and how many are not? I mean, that seems fairly basic.
We will try to obtain those metrics for you for FY26.
So do we have the information and we just don't know it, or?
We will try to get some metrics for this commission to consider, and for August's meeting, we'll work with CE Broker to see if we can
So one
get
other
some of that
question.
information.
When a course is approved, does the person submitting it put a cost on there?
No.
How much it's going to be how much they're going to charge?
No, we don't see that information.
Do we know if it's going to be if it's going to be free or not, or do we know nothing? We just say, here's the course. and
What
it's
we are
gonna happen.
concentrating on is that the instructor is qualified to instruct whatever the person is teaching.
Right.
And that the courses being offered are in line with the rules of, there are about 2 dozen items of what the course can be about as it pertains to real estate here in the state of Tennessee.
Can I respond to him? Our association actually provides several classes and courses for free to their members. Our association does that. And I'm sure there are other associations across the state that do the same thing. So as a member of that association, I could choose to go sit in that class for free, or I could choose to go to another class in another location and pay. So it depends on what my choices are. But I'm the one that makes that decision. Do I want to go for free? Do I want to go pay and go somewhere else? Or do I want to take it online? I'm not obligated to do just one.
And Trec team members are making a very concerted effort to crisscross the state and offer free continuing education. Brittany didn't mention, but we have offered over how many hours? We have offered over 1,100 hours of free CE across the state since July 1 of last year through June. We don't have any more scheduled. So through June 30th of this year, we've offered 1,100 hours across the state. And when we work with the local associations to offer these hours, we require that there is no fee for anyone, whether you're a member of that association or not, whether you're a member of the National Association or not. As long as you're a licensee in this state, you are allowed to take those 4 hours of free CE for free.
One last question. Do we know when we approve a course, if anyone ever takes it?
I would say that would be hard to say. There are some probably written courses because we still offer paper courses that someone may not necessarily take.
So we have a list right now. You said how many? 700 and some odd?
It's about 700 courses or so.
Courses.
760, I think.
So there's no monitoring if anyone ever takes the course. Is that?
There could be
I'm just
someone somewhere waiting, Steve. I don't know. I don't think we have those metrics though.
Okay.
There no other, that conversation carried on a lot longer than we expected. I sense the need for a break. So we're going to go ahead and take a break for 10 minutes. We'll be in recess until.
Let's say 10:25.
10:25 sounds good.
Thank you.
We're in recess. All right, this meeting is back in session. We left off in our agenda with the legislative update and rule review. I assume those are both going to be by Ms. Matlock.
Yes,
Ms.
that is
Matlock,
correct.
Please proceed.
Okay, the first thing I'm going to begin with is going to be a legislative update. General Assembly has finished session. Yay, everybody, round of applause. We're happy for it. Thank you. I wasn't meaning literal, but I appreciate it. So I want to go over the bills that I've been talking you about this session and letting you know the outcome of those. So the first one is SB 1786, HB 1916. So this is the bill that would have exempted certain the licensing requirements for affiliate brokers for vacation lodging services. If you remember last time in April, I told you that that bill had been placed behind the budget. Surprise, it was removed from behind the budget, and it is now considered to be Public Chapter 1786, Public Chapter 1095. So that bill related to vacation lodging services has gone into effect. And so that means moving forward that if you're an affiliate licensee and you're working in a vacation lodging service, you are not required to get the additional licensing requirements for a designated agent. However, the supervising of that person, if they're an affiliate broker or a broker, it still remains with their principal broker. So that bill was signed into law on May 22nd, 2026, and that is the date that it went into an effect. So moving forward, if an affiliate licensee wants to be a designated agent, they don't have to do a separate application process. Okay, any questions? All right, moving forward, the next bill that I want to discuss is going to be the Military Families Licensing Recognition Act, which was HB 1677, SB 1692. That bill also became public chapter. It became public chapter 955. And a recap of that bill, it requires that certain changes for military licensing related to dependents and I don't believe dependents made it into the final bill. So it's essentially a license portability type matter related to military licensing, and it gives us some additional requirements of what we have to do processing military applications for those persons that have active orders that are looking for licensure. So we already have military rules in place, and there are also federal military requirements. This doesn't circumvent either of those. So that bill went into effect upon becoming a law, and so that went into effect on May 7th, 2026.
So is the scenario contemplated of a active duty military person having a permanent change of station to the state of Tennessee and we're required to get a state license? And that would get
Right.
that kind of
So it could
reciprocity.
be a permanent station, temporary, whatever it may be. So we were already doing military licensing for those persons that come into the state that require real estate licensure. Also applies to their spouses as well.
Okay. Thank you.
Okay. And then the last bill that I want to discuss is going to be SB 2224, HB 2530, and that became public chapter 1039. And that had several different changes that were going to be made related to, first, we had several changes made to mailing. And we had changes related to the firm office requirements, such as, so you're not required to provide the commission when you make a firm application, a zoning letter. We don't require that anymore. I know. So a zoning letter, that doesn't mean that that person can just say, oh, I don't care about zoning. That means if it's a zoning issue, that's between you and the board of zoning folks with your local zoning. Also, it changed the post continuing education requirement from 3 years to 4 years. So now you have 4 years to complete that 120 hours, which had already been in effect, but it will remove that penalty that comes with the 4th year. But so that individuals have 4 years to complete their broker post 120. And then another change that came from it is related to post-licensure criminal convictions. So post-licensure criminal convictions are essentially expanded. Previously, the law, what it states right now, says if you already have a real estate license and you've pled guilty or are convicted of a crime related to bribery, embezzlement, anything related to essentially money and dishonesty, your license could be automatically revoked. However, now it's going to include violent or crimes where force was used related to misdemeanors and felonies. So if an individual, for example, had been convicted of aggravated assault after your license, then the commission has the ability to revoke your license after that. So it's all of these changes that I'm stating right now don't go into effect until July 1 of 2026, but they go into effect right now for rulemaking purposes, which is why I brought a rulemaking package before you, that you'll see some of the changes from this law that go into effect. Any questions? Okay. So I will, that information, we will one day send out an update to licensees, letting them know of the new statutory changes that we have had. It'll be communicated in a form or fashion somehow, letting them know because we've had some changes that occur. And then now I'm going to move into discussing the rules that we have that are going to be changed. as a result of some statutory changes, but also we have some cleanup items that are in there. But first, before that, I wanted to introduce you to two different people. You may see them sitting over here, over my shoulder. We have two summer clerks that are going to be working with us this summer. I have Miss Aya Sibai. She is a rising 2L at Belmont University, and also sitting next to her is Mr. Phillips Huh, and he is a rising 2L at Vanderbilt University. So they're going to be helping us with some work this summer, and they'll be here at this meeting and probably in August, and then we'll send them back to law school for fun. But does everyone have a copy of the rules in front of them on the iPads?
I don't have them on the iPad.
Okay. It's fine. I will talk to you about them.
Unless I missed them. No bueno.
Let's do this. Can we move into the legal report, and then I will get some copies of these rules and we can discuss them after that?
Commissioners, how do we feel about that, doing a legal report?
Or do you want me to just go through them, or do you want to like physically see the changes? If you want me to just talk through them, that's fine. It's up to you what you would like to do.
An option is also for her to share it with me, and I can share it on the screen as well, whichever you all prefer.
Commissioners, what is your sense? You just want to have her deliver them? We happy to listen, or do we need to see it? Ms. Matlock.
All right, well, more of my voice. With no, okay, so let me pull up the rules really quickly. No, it's okay. Don't worry about it. Thank you. Okay, so the first change we're going to be making is going to be to Rule 1260-01-.21. So that is the rule that is related to reinstatement of an expired license of a broker or affiliate after 1 year. And so that was a statutory change that occurred before. So essentially what happened was we have changed the requirements. In the statute, it said more than 2 years, you had to do certain things, but now it's just more than 1 year. And so it reflects those changes. So now if an individual has a license expired more than 1 year, they are required to pay the penalty fees that are listed in the rule and complete the trace course. This does not apply to individuals that are in temporary retirement because those changes are outlined elsewhere. And then, of course, as CE is not required of individuals that supervise affiliate brokers or brokers that do not supervise them, those grandfathered folks, this would not apply to them, the education that is required. Does that make sense?
And the section where it says the 30 hours.
Yes.
So I know that our trace course is 30 hours. Did you avoid specifically naming that course and just any 30 hours? Or?
Well, it's of the commission approved 30-hour course. It's the trace course now, but in the future, if it changed names, that will require a name change. So we know that the 30-hour course is the trace course.
Okay.
So
it's not any 30 hours.
No,
Okay.
It's completion of the commission approved 30-hour course. And so when we're drafting rules, we try to make them as specific, but not super specific, because if it were to change one day and we decide to not call it trace and we decide to call it something else, then it would require a rule change.
The person that holds your role in the future would be grateful.
They should be. But also, are you trying to get rid of me? We'll talk about it later. It's okay. The next change we have is going to be to Rule 1260-02-.03 for offices. You'll see that we have removed the zoning requirement there and just renumbered the rule next paragraph from 2 to 3. Okay, so this is one of the clerical changes that I mentioned. Following up what you were saying before, Commissioner Diaz, we try to be specific, but not super specific. So in the 126002-0.37, the end, the area that you received the septic letter that's mentioned here still comes from the Tennessee Department of Environment and Conservation, but is no longer called the Division of Groundwater Protection. So that is outdated. I don't know what the new name is, but the septic letters that come from there will come from where they're supposed to be. So we're going to remove that. The next one is a very minor change. It is removing the F from, this is Rule 1260-06-0.09, exchange agents. It is citing to, this is in the timeshare chapter. So it's citing to subsection F when it actually could mean subsections E and F. So we're just going to go ahead and delete that. Right there. Yep.
So small, I didn't see it.
All right. And then the last two changes that you're going to see are going to be in the vacation lodging services section. So in 1260-07-0.02, the language for vacation lodging services, if any individual in vacation lodging service or a designated agent is making an application and they have a criminal conviction that's related to theft of money, services, or property, or a felony, they're still required to come before the commission. And that's what it stated over there in paragraph 3. What I've done is I've taken the language from 1260-01-0.01 paragraph 5, and I have mirrored that here in paragraph 3 of the designated agent rules. So the process is still the same. It is just going to be there. I think it's important to mirror it for clarity purposes.
So just out of curiosity, not necessarily related to the rule, but when it's talking about an applicant who had pled guilty or no low contender, I've become familiar with an Alfred plea.
Mm-hmm.
Is that also just pleading guilty and
An Alfred plea, if I'm not wrong, is when you accept, you don't essentially plead guilty or not guilty, but it is kind of the same as
acknowledging the state has enough evidence to convict you.
Yes, correct.
Okay.
You're basically, it's a neutral type thing, but it counts as a conviction. So,
Okay. Thank you.
but you're not admitting. So I had it right. Yes, you did. Okay. Yeah.
Very good. Thank you.
I've not seen an individual come with an Alfred plea, but if it were, it would come before them. As Ms. Cooper said, it's rare, but we do oftentimes see individuals that have pretrial diversion or where adjudication has been withheld or any of those types of those matters. So those don't come before you. It's just going to be anything that is the equivalent of a plea or a conviction. Okay, so that is literally the same language from 1260-01-0.01 paragraph 5, copied and pasted. The only thing that you'll see that has been removed from it is to tell that, to require that individual to appear before the commission with their principal broker, because designated agents don't have principal brokers. Okay, and then the last one is it's going to be creating a new paragraph 4 for 1260-07-0.02. So it's stating that the requirements of this rule do not apply to an affiliate broker or broker licensed under this chapter as stated in 6213-104B3. So that is as a direct result of the statutory change that occurred recently. So these are the rule changes. What I will need to move forward is for the commission to vote to approve the language. And then what will happen after that is we'll have the internal approval throughout in the department and then get approval from the governor's office of the rules. And then it will proceed to a rulemaking hearing. My target date is going to be October for the rulemaking hearing because I won't have enough time between now and August to do it. So that's what the hope is for. But if not October, we'll be in December.
All right. So is there a motion to accept these rules changes as presented by council?
Second.
Have a motion to approve by Commissioner Gwynn, seconded by Commissioner Smith. Any further discussion on the rules? Hearing none, all those in favor of the motion, please say aye. Any opposed? Hearing none, that motion carries unanimously. Is that good, Ms. Matlock?
Yes, thank you. That concludes my updates related to the rules and legislation. I just wanted to double check one more time before I pass it over to Ms. Cooper and Ms. Carter to see if there were any additional questions from the commission about anything that I presented today. I'm that good? Okay. Over to Ariel and Kim.
All right, next item on the agenda is the legal and consent report. Commissioners are presented with a packet of information that contains narratives on the cases that are going to be heard in this meeting, and commissioners have an opportunity to pull individual cases for questions or further discussion or to modify council's recommendation. Chair will entertain a motion to accept council's recommendation in all of these cases except the following. Case number 2, 7, 28, 31, 32, 36, 41, 44, 47, 62, 63, 88, 68, 88, 96, 137, 138, and 149. Are there other cases that commissioners wish to pull that have not been stated?
Does that include the addendum we got?
It does not include the addendum that we have got. Those cases weren't pulled by anybody, I imagine. So we're going to consider the legal report en bloc, both the legal report we were presented prior and the addendum that we received yesterday and this morning.
So it'd be numbers 1 through 152.
Correct.
Okay. That includes renumbering the addendum cases. Oh, sorry, whatever the last number, hold on, of the legal report. So the last number of the legal report is
149.
149. Yeah, so renumbering the addendum
So
cases to 150, 151, and 152.
That's correct.
Okay.
So is there a motion to accept council's recommendation in the legal and consent report as amended, minus the cases that were read into the record?
I make that motion.
Second.
I have a motion made by Commissioner Smith, seconded by Commissioner Torbett. Any further discussion on that motion? Hearing none, all those in favor of the motion, please say aye. Aye. Any opposed? Hearing none, that motion carries unanimously. First case was pulled was case number 2. I pulled that one, and this is more of a curiosity thing. So the language that you quoted in this case, is that meant for like third-party sites like Zillow and Redfin or MLS? Do you know where it was posted?
What I saw, it was on an MLS listing.
Okay. So okay, so what in this language did triggered your recommendation to find a violation on this rule 1260.02.127B?
My concern specifically, I think, was with the exclusive programs that are only available through the listing agent.
Mm-hmm. What you saw in the MLS was the contact information for the listing agent there? Okay. So the exclusivity of it is what triggered what prompted you to make the suggestion?
That was my concern, yes. If I've misread that or misunderstood what the intent was there, I'm happy to do another letter of warning or instruction. I just, especially since they have had one similar previously that we've already instructed them on, that's why I made that
Right.
recommendation.
I mean, I think it's been the experience of a lot of agents when they're dealing with Zillow and Redfin that they have the contact the agent button, but that button doesn't necessarily connect to the listing agent. It might connect to another agent. Has that been other commissioners' experience? Or I mean, I can see my way to a letter of warning. But I'd be interested to hear what other commissioners think. Or there could be a motion just to accept council's recommendation, whatever y'all want to do. Make a motion to accept. I have a motion by Commissioner Gahn to accept council's recommendation in case number 2, seconded by Commissioner Tucker. Any further discussion? Hearing none, all those in favor of the motion, please say aye. Any opposed? Hearing none, that motion carries unanimously. Case number 7. So this one, you recommended a downgrade from broker to affiliate. Is that correct?
Yes, sir.
Okay, so let's go ahead and expand on your reasoning, how you got there.
The summary is a bit lengthy, but essentially you have a real estate investment company comprised of 3 individuals, one of which met with the owner and seller of the property. They were introduced to the seller by a friend of the seller. The seller had the conversation with them about how much money they wanted and about how there would be extensive rehabilitation needed. So it was going to be an expensive project. The investors were still interested, made an offer, contract was executed. They are alleging that the respondent had already had a conversation, allegedly, that they were interested in the property, but no agency agreement had been signed, no purchase agreement had been signed, nothing like that. The respondent allegedly became upset when they learned that someone else had entered into an agreement to buy the property, and alleged that they were, 1, engaging in unlicensed activity, and 2, that they were taking advantage of a disabled or mentally unfit person. The respondent made that allegation without ever having met with the seller. The complainant met with the seller at least twice, and had no reason to think, they say, that this person was incapacitated in any way. The respondent then reached out to a family member of the owner and seller, and allegedly stated that they could get them a better deal if they would just talk this other family member into breaking their agreement with the complainant and listing with them. I thought it was pretty egregious, what they did. There was a statement from a friend of the owner, the actual friend that introduced the buyer and the owner, who was present for the full conversation regarding what they wanted to do and what this person's plans were, that said, no, they're fine. They're not incapacitated in any way. They are elderly, but they are not incompetent. And so that's why I made that recommendation. There were a lot of moving parts there where at any point this respondent could have taken a step back and said, I need to stop what I'm doing. And they just kept going.
So if I understand the scorecard and the timeline right, the complainant and the seller reached a deal, signed the paperwork, and they were going forward. And the respondent is coming in after this deal has already been made, trying to undo it
Yes,
and making all the allegations you said he made.
correct.
Good. Thank you. Council's recommendation was for the downgrade and a penalty of $1,000. Is there a motion?
I make a motion to accept council's recommendation.
I have a motion by Commissioner Smith to accept council's recommendation in case number 7, seconded by Commissioner Torbett. All those in favor of the motion, please say aye. Aye. Any opposed? Hearing none, that motion carries unanimously. Case number 28, Commissioner Smith. Okay, you go first.
You want to give us a little synopsis of that?
The complainant is also a licensee. They had a client that received a mailer / letter from the respondent that said that they had a guaranteed cash buyer for their home, and that the letter did state, if you're currently listed, this is not an attempt to solicit your listing, but it was also stated that it would be you would be better off if you went directly to the complainant. So they made that complaint. The respondent stated that, you know, it was not an attempt to solicit an active listing. They didn't encourage the seller to cancel, breach, or circumvent an existing relationship. They also said that this was a geographically based mass mailing that wasn't targeting any specific seller, I guess, for lack of a better word, but they were just on their mailing list, so that's why they got the letter, and that they would never intentionally mail to someone signed under a listing agreement with another agent. The reason that I asked for a discussion on this is just because of the history, most of it advertising violations of this respondent.
And so I tallied it up. It was 7 advertising violations and 3 failure to supervise for E&O.
Correct. Now, to be fair, this complaint came in right after another complaint that you have heard recently, and they were ordered to take the trace course. They just submitted completion of that. And they probably, these two, that complaint and this complaint probably should have been on the same legal report, but because of timing, they just weren't. So I don't want to say that I'm piling on, but they have just
make them do it again. Make them do it again.
Yeah. So.
Right. Okay. So can you tell us if there was a civil penalty on all of these, any of these past charges, or
The last one,
consent order? Okay.
there have been civil penalties. I believe that you maxed out the $1,000 on at least the last one, maybe the last 2.
So this is seems like this applicant is decided this is the cost of doing business kind of thing. Commissioner Smith, what do you think?
I think I'm suggesting $1,000 civil penalty is what I'm thinking.
So the license type is an affiliate broker.
Yes.
So they've been downgraded before, or?
Yes, they have.
Okay.
So
There is an ad course, right, Ms. Morris?
There are several advertising courses, but most of them do come from specifically the Trec course. I would say goes into most detail about the actual rules and statutes related to that.
Okay. I'm gonna make a motion, okay?
At your discretion.
I'll make a motion of $1,000 civil penalty and take the Trec course within 30 days and that not to go to continuing education.
A motion by Commissioner Smith to offer this licensee in case number 28, $1,000 civil penalty, and to take the Trec core course to be completed within 30 days and to not count towards their continuing education. Seconded by Commissioner Moffett. Any further discussion on the motion?
A question.
Go ahead, Commissioner Gahn.
Can they get that core course within 30 days?
You can do it online.
There are a variety of ways the course is offered.
Any further discussion or questions? Hearing none, let's vote. All those in favor of the motion, please say aye. Any opposed? Hearing none, that motion carries unanimously. Case number 31, Commissioner Smith.
Yes, on number 31, should there be a penalty for no response? But you can't do a penalty if the license is expired? Is that my question?
Is it your question?
That is my question. The license has expired. So what can we do?
Let me check and make sure that the mail didn't come back, because their license has been expired for a while.
A couple of years.
Now it looks like it was delivered.
It's what?
It looks like it was delivered. Yes, ma'am. It didn't come back, and there's a signed certified mail receipt, so they did receive it. They just chose not to respond. But again, since the license is expired and has been for
Since 2024.
yes, ma'am.
So we don't know if they're still with the firm or practicing or not.
They've been released from the firm.
Okay.
As a result of the audit. The principal broker stated that they just realized they were still on their roster. So
Right.
they've been released. But other than them just being on the roster after their license expired, I don't see any proof of any unlicensed activity.
Okay.
Were you able to see if they landed someplace else, or they just
They just didn't renew their license and don't appear to be
practicing?
correct.
Maybe close and flag.
I can certainly do that. And if new information comes up, I can represent it.
Commissioner
That would
Smith, what
be
do you
the
think about
motion.
it?
Closing flag. Case number 31.
Second.
Have a motion by Commissioner Smith to close and flag case number 31, seconded by Commissioner Wampy. Am I saying it wrong?
Yes, Rampy.
I get the Wyatt and the Rampy mixed up. I'll straighten it out here in a second. Yeah, so
You're confusing me.
I am Commissioner Rampy. Apologies. Any further discussion on the motion? Hearing none, let's vote. All those in favor of the motion, please say aye.
Aye.
Any opposed? Hearing none, that motion carries unanimously. Case number 32, Commissioner Smith.
Same question, so I will make a motion that we close and flag that one also. Second.
I have a motion to close and flag case number 32 by Commissioner Smith, seconded by Commissioner Torbett. All those in favor of the motion, please say aye. Any opposed? Hearing none, that motion carries unanimously. Case number 36, that's me. So if I understand this narrative correctly, it wasn't the fact that they were advertising properties for other owners and that's not their own properties, so they don't qualify for an exemption?
Correct. They are advertising property management services for owners of other properties. The website is pretty specific that they can step in and help struggling homeowners or property owners who have rentals that are not getting the return that they would like, so that they'll come in and fix that.
Okay. So council's recommendation was a civil penalty of $1,000 for unlicensed activity by acting as a property management firm without a license. Is there a motion?
Make a motion that we accept council's recommendation.
A motion by Commissioner Smith to accept council's recommendation in case number 36, seconded by Commissioner Tucker.
Question.
Commissioner Gwen.
It says the complaint was opened by who? It says due to suspected, the complaint was opened by,
There was a previous complaint that alleged unlicensed activity that was closed because of some technical issues. So I went back and opened the more recent website to see if it was an ongoing issue, and it was.
so it should be complaint was opened by staff?
Yes.
Okay. That's it.
Any further questions on the motion? Hearing none, let's vote. All those in favor of the motion, please say aye. Any opposed? Hearing none, that motion carries unanimously. Case number 41 was marked for discussion. Ms. Cooper, what would you like us to know about case 41?
So this is another case that was referred for suspected unlicensed activity as a result of an audit. And it's another principal broker who stated that they did not know that they had affiliates that had expired licenses. Unlike the previous complaint that was somewhat similar in that regard, in this case, the respondent While asserting that none of them had engaged in unlicensed activity, 5 of the 7 went ahead and immediately renewed their license once they found out that they were expired. And 2 of the other 2 have been broker released. And so that spidey sense in a way perked up. And that's why I wanted the discussion. It would be one thing if they had moved out of state or there was nothing going on with these people like in the previous situation. But in this case, they, like I said, immediately renewed their license and they're still actively practicing with this firm. The other concern I had, and I think I wanted it discussed just so it can be clear to anyone watching, that the state association and the professional associations are not you. They are not the Tennessee Real Estate Commission. It is your responsibility to keep up with whether or not your license is expired. And they are separate entities and you should not rely on professional associations to notify you of license expirations. The commission staff does a wonderful job of letting everyone know that renewal is coming up and what you need to do. This principal broker seemed to be, I don't want to say confused, but conflated the two. And asserted in some sense that it was the association's fault or the commission's fault for not letting them know that these licenses were expired. And that's just not the professional way to do things. And I don't know where that confusion came from, but again, I just wanted that to be out there.
So y'all showed up to do an audit and the lights came on and everybody scattered, huh?
I can always speculate. Yes, sir.
I'm just curious, how many agents are under this broker?
That's a good question. Let's see. Relations. Well, it looks like now, hold on. Am I reading this wrong, Ms. Baker? Oh, I'm sorry. I'm reading it wrong. Oh, because they're moving, that's why. Let me see. That's it. Yeah. It takes a second. Multiple screens to go through to get to the information. This one. This? License relations. Yep. Did she just switch? She just did. Yeah.
A lot?
A lot. A lot. More than will fit on one screen.
I would say more than at least more than 50.
Yeah.
50. Okay. So not 1,000. Okay.
Was there any proof of unlicensed activity during that period of time?
No.
And it's the broker's responsibility to be sure they have licensed agents. I'm just reiterating what
Yes,
we
ma'am.
know
That's
as a
the
fact.
most basic supervisory responsibility, I would say.
So, and that's exactly what I wrote down. I said maintenance of the license belongs to the licensee, cannot be delegated. So even if it's a employee of the firm, that still doesn't relieve you of your obligation to maintain your license.
Right.
So are you seeking a civil penalty against the broker or?
Not necessarily. I would, at the very least, request a letter of warning to this principal broker regarding.
How long is this? Because in the past, if there's been a transition from one principal broker to another, we've kind of shown a little bit of grace there. Do we know if this principal broker has been the principal broker the entire time?
And we also have already 2 letters of warning. or one letter of warning and a consent order.
Yeah, it looks like 50 is too much because he
Yeah.
can't supervise the affiliate.
It looks like they are in the process of transferring to a different firm, so they will not be supervising. It doesn't look like nearly as many affiliates. So
Commissioners, what do we think?
I've got a question. Back on so the person was licensed in 2005, but not necessarily as a firm. What about the person, the principal broker?
the principal broker was initially licensed in 2005.
That's what I was, okay.
Yeah.
So I find it hard to believe that a person licensed 21 years is now just figuring out that a state association is different than the Tennessee Real Estate Commission.
And Commissioner, that was my concern as well.
And they're now just doing a proactive system to monitor this after 20 years or whatever it may be.
So there's also maybe instead of or in addition to, there's the broker core course. We can have them take just as an option. What are our thoughts, commissioners?
So they've gotten they've got the two instances that did not involve a fine, right? So the principal broker has a history of failure to supervise.
It didn't involve a civil penalty.
Correct.
And it doesn't appear that she'll be the principal broker of the firm that she's moving to.
So if we assess a civil penalty, it's going to be with a firm that still exists, but that managing broker is moving to another firm. Is that what you're telling me?
Well, it looks like the complaint was open against the principal broker, so it should follow her.
It would go with
or
her.
whoever it is.
Yes, it would go to the respondent who is an individual. The complaint was opened against the principal broker, not against the firm, as Commissioner Diaz said.
Is this person moving back into a managing broker position?
That'd be hard to know.
Well, they may.
I mean, she could, or he or she could become a managing broker at any time.
Well, that's true. Okay, I'm gonna make a motion that we assess $1,000 civil penalty and require the broker core class to be taken within 30 days with no CE.
We don't necessarily have a broker core
Oh, okay.
course.
I
We
thought
have
you said we
commercial
did.
and residential.
Okay,
I
the
see.
residential core class
But it's not a core course.
within 30 days. Is that doable?
So Ms. Morris, it seems to be that there's a
There's a
course
course
may apply?
that people market to brokers. However, as far as Trec is concerned, there are two types of core courses, a residential core as well as a
Okay.
commercial core.
So
I'm
what's
gonna
the,
restate mine.
I was going to ask, what is the name of the course that is marketed for brokers?
Core.
It's core. It's the residential core course if they're selling
Okay.
traditional real estate and not commercial.
Commissioner
So
Smith.
$1,000 civil penalty, 30 days to take the core class and that to go to no CE credit.
So Commissioner Smith makes a motion to assess a $1,000 civil penalty against this respondent in case number 41. And also to require that they take the residential core course within 30 days, and that course does not count towards their continuing education. Is there a second?
And to be clear, this is failure to supervise the activities of their affiliates.
Yes. That motion was seconded by Commissioner Moffitt, and there's questions. Commissioner Smith.
What is
Go ahead.
the fine for?
Failure to
supervise.
Supervise, all right.
Any other questions regarding the motion? Hearing none, let's vote. All those in favor of the motion, please say aye.
Aye.
Any opposed? Hearing none, that motion carries unanimously. Case number 44, that's me. Okay, so this one, the council's recommendation was for a civil penalty of $1,000 for unlicensed activity. In their response, they said that they briefly managed properties for personal acquaintances and were unaware of a license, that they needed a license to do so. Was your sense that this is somebody that's not a professional property manager and it was just doing the work as a favor, or?
I got the sense that they were attempting to start a business, go down that path to being that business that would be a property management company.
Right.
But that they had just started out and were sincerely not aware. I did check the updated website and they did do what they said in their response, that they removed it. Any indications of property management in this sense of anything that would need a license, they now offer services like maintenance, and are looking into what they need to do to get the proper licensure.
So the respondent is not a licensed affiliate or anything. They're not.
No, sir.
I make a motion they be issued a letter of warning.
I have a motion.
Second.
I have a motion to offer the respondent a letter of warning in case number 44, seconded by Commissioner Gwen. Any further discussion on the motion, Commissioner
I
Torb?
feel like I ask this question often, but if they're not a licensed agent, what authority do we have over them at all?
The statute allows you all to enforce sanctions against unlicensed activity. Regarding regulation and meeting requirements of licensure, obviously you have that authority to do as well. The letter of warning is just kind of a, hey, don't do that again.
Right.
But
So the letter of warning is easy enough to do, but if we did enforce a civil penalty, there's no way to force them to pay that unless they wanted to get their license, correct?
Oh, no, ma'am. We have hearings on unlicensed activity all the time in front of administrative law judges. And if I didn't understand your question initially, I'm sorry. We have hearings all the time. If an administrative law judge issues an order finding them guilty of unlicensed activity, I had one just last week, then they are ordered to pay the $1,000. If they don't pay the $1,000 plus court costs and any associated attorney's fees, then we turn it over to the Attorney General's office to go after them, and they do.
Okay.
They can put liens on properties to enforce that judgment. They're just the way that you would enforce any other money judgment.
Thank you.
Yes, ma'am.
Okay. So we have a motion. Any further discussion on the motion? Hearing none, let's vote. All those in favor of the motion to issue a letter of warning in case number 44, please say aye. Any opposed? Hearing none, that motion carries unanimously. Case number 47 is also me. All right, so
Most of this discussion already took place.
yes,
Yes,
most
sir.
of this discussion already took place.
Yes, sir.
So,
Based on that discussion, my recommendation would be to dismiss. This is a multi-suite office building. They are in one suite. The firm, the academy is 6 suites down. Yes, they all are in the same building. I have no indication that there's a door between the two or that they're adjoining or using the same services or anything like that. So based on the prior discussion, I would recommend dismiss.
all right, council's recommendation is to dismiss. Does anybody want to further discuss the option here or make a motion?
Second.
I have a motion by Commissioner Gahn to accept council's recommendation to dismiss case number 47, seconded by Commissioner Torvet. Any discussion or questions? Hearing none, all those in favor of the motion, please say aye. Any opposed? Hearing none, that motion carries unanimously. Case number 62, Commissioner Smith.
62 is blank. I'm not sure what happened there, and I apologize for that. I would ask that you all,
So it's a motion to dismiss then?
they would appreciate it probably. No, if we could bump that to the August report, I would appreciate it.
All right, so we will defer case number 62 to the August report. Is there a motion to that effect?
So moved. Second.
Have a motion's been made by Commissioner Torbett, seconded by Commissioner Tucker. All those in favor, please say aye. Any opposed? Hearing none, that motion carries unanimously. Case number 63. Both of
63,
us.
I did not put a recommendation on, and I apologize for that as well. I do have some concerns about the respondent in this matter. They have built up several recent complaints for different activities that they haven't responded to any of them. We haven't been able to get them to respond to anything, phone calls, emails, letters, certified letters, everything's been returned. Their license has expired. I believe their firm license has also expired. I know that the typical civil penalty for failure to respond is $1,000. But again, their license expired in February. So I throw it to the commission what you'd like me to do with that one.
So their license is an expired grace, but that also gives them the possibility of paying the fees, taking the education, and coming back into active status.
Yes, that's correct.
If we revoke that license, then they have to go and they have to retest and reapply if they want to continue doing business.
Well, there's a process to revoking the license because they could appeal that revocation.
Right, but if we offer them that, they would respond however they wanted to respond at that point.
One would hope.
I even checked obituaries because I just did not understand how we had nothing and didn't find
Did you
anything there.
call hospitals and morgues? Were you doing?
I almost did. So yeah, they just seem to have disappeared off the face of the earth. So
Okay,
Maybe they won the lottery.
maybe they did.
But you said there are multiple complaints. Where are the complaints originating? Are they staff
Yes.
opened?
Yes,
Oh,
sir.
okay.
Not us staff opened, I'm sorry. They're former affiliates of this principal broker who became concerned because they couldn't get them to respond to, they weren't getting paid, or there were some disagreements about employment status, and then they just apparently, like I said, took off and disappeared. So
So have those affiliates transferred their licenses elsewhere
I believe
since?
so. Yes, sir.
Okay.
Okay, if we revoke the license, then it's a start over process form,
I
If
believe
they
so.
accept it,
if they
yes.
accept that.
Yes, ma'am.
So we could revoke or we could close and flag and see if they resurface at some point.
I defer to you all, but yes, sir. You could do either.
Can we revoke a license that has expired?
Yes.
Okay.
Just for, I would suggest they made it possible to do that for situations like this, where you have a bad actor who let their license expire, thinks that, if I wait a year or two, and clear up whatever I need to clear up, and then I can come back and just try to get my license back. In this case, if we go ahead with the revocation, that'll be on their file, and we can say, wait a minute, you need to come in front of the commission and talk about this.
Yeah. It also would show up if they are in another state and try to activate a license in that state.
Correct.
If they try to get a license
Correct.
history. So,
Make a motion that we revoke the license.
Second.
ooh, eager. All right, we have a motion by Commissioner Smith to revoke the license in case number 63, seconded by Commissioner Gwynn. I think he beat you by a second, Mike. Any further discussion on the motion? Hearing none, all those in favor of the motion, please say aye. Any opposed? Hearing none, that motion carries unanimously. Case number 68 is a me. So this one, your recommendation was to offer a letter of warning.
Yes, sir.
Oh, okay. So this is a represent. I'm
Yes,
sorry.
sir.
Initial recommendation was to downgrade. We accepted. Okay. So they thought their hours had been reported
Yes, sir.
and they were not.
That's what they reported to me.
And
Yes, sir.
they had their certificates to say that they did it.
They had a printout. Now, this is where it gets difficult if we were to have a hearing. And that's my concern, is I don't know that I can prove this if we have a hearing, which is why I'm asking for a letter of warning. Everything about this predates our current staff. So it was not Ms. Morris who confirmed or did that. It is not Director Baker who would be able to testify to personal information or personal facts about what happened. Those people have moved on. I have a respondent who says, I did it. There was also the situation in 2019, I guess, or 2022, where there was issues with reporting. So there was already something odd going on. And then you have this one respondent who apparently was caught up in that. Since this incident, and since she said, I did what I was supposed to do, and here's this printout, and I don't know why it wasn't reported, they've done everything else they were supposed to do. They're in good standing. They're still a principal broker. I haven't had any further, nothing else has come to us.
So, and that printout shows the courses that they took, that they were completed, that they got the number of hours, et
Yes.
cetera.
And why they have it and it wasn't given to us, I don't know.
So, and that printout came from a provider that we recognize.
It came from her, or from them, but they said but it's a provider that we do recognize.
No reason to question that, the authenticity of that at all.
I have lots of reasons to question everything, but, and to Ms. Morris's credit, she was like, we can do this. But I just, because of the age of the case and because nobody is still here that had anything to do with it, I can't sit them down and say what happened here.
Okay.
So a hearing would be, I think, a waste of resources.
Okay. So a new recommendation is to offer a letter of warning in case number 68. Is there a motion?
Motion.
Motion by Commissioner Rampy to accept council's recommendation to issue a letter of warning in case number 68, seconded by Commissioner Torvik. I got them both right. Is there any further discussion? Hearing none, let's vote. All those in favor of the motion, please say aye. Any opposed? Hearing none, that motion carries unanimously. Case number 88, Commissioner Smith.
My note says, can you ask for respondent to send advertisement? I don't know what that's.
Commissioner Smith, will you turn on your microphone, please? Thank you.
I had a note. Can you ask for respondent to send advertising?
Like the full advertisement, or?
I've got to.
Because in the complaint there was like a portion of it, like from social media. But not the entire one in the complaint. And since they were anonymous, couldn't ask them for additional information. I could ask the respondent if it's still posted, but I'm not sure if it still exists or not.
It concerned me that we're offering, someone is offering a medical treatment as a giveaway. Does that not red flag everything?
I think like in context, it was like part of like a health kick situation because there's also like a walking pad for like another gift and a gift basket for a gym and another like 3-month gym membership and something from Dick's Sporting Goods and IV hydration. But the way they explained it in the response was that everything that would be conducted would be by a medical professional. My assumption is that additional details were provided, not in this post, that was just like a portion of it. But since I didn't have that information, I couldn't just make that assumption.
I guess that's why you wanted to add to be reviewed by staff.
I guess that's why I made that note. It just struck me odd. So I guess.
So yeah, being able to see, I guess staff being able to see the advertisement in its entirety, as opposed to what the complainant has pulled out and complained about, I think would be informative. Respondent didn't give you the full advertisement. They just responded to the allegations.
Correct. And they like also forwarded something from the Associated Medical Facility. I'm trying not to give away the name or anything like that, but like a person on staff with that medically licensed facility, like and how it would work and who would be performing everything. It was like essentially like an email verifying like how it would work to me.
So have you seen the advertisement or?
I only saw the portion of it. Essentially what I received was an email from the respondent and the medical provider saying like, this is what the situation was, this is what our agreement was, and here's how it worked, and here's who would have done the service. And it would have been licensed, essentially is what so all I got was an email from them.
Was it like an online ad or a print ad, or do you know that?
It was on social media. So it was just like a screenshot of like a post from social media.
It's very odd.
It's hard to say if you don't have the entire ad. So it's hard to say dismiss when you don't have the whole thing.
So,
or letter of warning when you don't have the entire ad. So what options do I have?
so typically, once they respond, we have a hard time going back to them and asking them to respond again.
Yeah, I can read like what the
Yeah.
actual like content of what is shown in the complaint is.
Yeah.
But I'm not sure it's not gonna be super helpful, but I can give that to you guys. So the post comes from the respondent. It says like, are you trying to focus on your health in 2026? While we're dialing in to jumpstart your goals, we'll be hosting 6 open houses on Saturday, the 10th from 12 to 3. Each one will have a prize you can enter for. You don't have to go to them all to win. It just increases your chances of winning something you can, if you can. Sorry, guys, lender and other agents can't qualify to win. Here's what we're giving away. Then it says 3 months of GLP-1, a walking pad, a free in-body scan, and gift basket from a specific place and city. And then a 3-month gym membership to a specific gym, a Dick's Sporting Good gift certificate, and then IV hydration. The open house addresses will be posted on Thursday. We will not disclose what prizes at which home. That ruins the surprise of the fun. Let's see. We also have a lender on site in case you fall in love with the home and want to get pre-approved. The live drawing will be done on this page, so make sure you follow along. Plus, you can see when we got more stuff in the works because we're always planning something.
Mm-hmm.
And then there's like a little
So nowhere in
infographic.
what the respondent provided did they discuss consulting with a medical professional and being medically evaluated before anything is dispensed. They don't say any of that, or there was no link from the social media post where all those details were contained.
It's like, I think it goes, it continues, but just like what was given in the complaint, no.
I think it's healthy to mention that there are 3 different ads that were submitted as a part of this complaint with similar verbiage in each advertisement. It also should be noticed something that Ariel said. It states either a sporting goods gift card, and then another advertisement says a sporting goods gift certificate. So I think we should.
So that's cash prize too, then.
This is a new one. I have not seen.
This is new.
Do you change your mind from dismiss to something else? Like we're up here thinking we need to do something besides dismiss?
I'll leave it to you guys to make that decision.
That's a good save.
I would say from a hearing perspective, if the respondent doesn't want to provide additional information or the full ad, it may be a little bit difficult to proceed based off what is in the complaint, and also getting the complaint, like the clinic to come in, to say like, this is what I saw on this date. We just don't have that person to come in as a witness, although we have this and like, we can make it work, but it would just be a little bit difficult from a hearing perspective.
So a letter of warning would give them the opportunity to come in.
No, a letter of warning would close the matter, but it would just.
Penalty would.
A civil penalty.
If they don't accept
If they don't accept, but a letter of warning would not.
Correct. That would just go on
Correct.
like in their account, and we'd be able to see that they got a letter of warning and what it was regarding. But it would be closed as soon as it was sent out to them, basically.
Please note that they are offering cash prizes as a part of
Yes.
participation
Oh,
on
Yes.
3 different advertisements that were submitted anonymously.
and
so
it's
each
my
ad
understanding.
is a separate violation then?
That
Could
is
be.
what I see.
It
Could
could
be.
be. Yeah. So it's like the respondent's like firm, it looks like, and then another respondent firm. It appeared like, again, I don't know when the screenshots were taken, but
And there's some
names are
history there
there.
for failure to exercise reasonable skill and care.
So the violation is not the GLP business. It's that they did not specify the amount of the cash, the gift.
It's that they offered cash. Although the other thing is, I think bizarre.
Yes.
Yeah. The disclosure is like the other issue and like the specifications. We don't have enough to say.
Yeah, I
that
think
there
that's.
Well, and part of the rule is they have to disclose all the pertinent details of the giveaway. And having to go see a medical professional, I think, is an important step that anybody in the raffle would want to know, because they have their own doctors that they may want to go see that are not part of this raffle, because he collaborated with a specific practitioner and not a general practitioner. That's my sense. Ms. Carter, is that right?
Yeah, it's a specific like a medical spa that like offers.
Yeah, okay.
Like
But we also
that.
have the issue of offering cash.
Mhm.
Yes.
So
So like, yeah, it wasn't 100% just because like the portion that was like cropped out, if there were details given or not. That's why the recommendation was just for dismiss, because I just didn't have enough information to kind of go off of for that. But whatever the commission
So
wants
it
to do,
seems
I'm
like,
here.
commissioners, if we're not inclined to dismiss this case, that there is an opportunity to offer civil penalty for 1 or 3 violations, and to also have a separate violation for not disclosing pertinent details on the face of the ad or within 1 click. And that's Tennessee Rule 1260.02.331, as quoted by Ms. Carter. So what is your pleasure, commissioners?
I make a motion that we assess a $500 civil penalty for each one of the violations.
Second.
So Ms. Smith makes a motion to assess a $500 civil penalty for each of the violations. So that would be 4 violations, so a total of $2,000.
No, sir.
It's only 3.
There are 3 ads.
There's 3.
3 ads?
That's what I see.
So 3 ads, but we're also including the failure to disclose pertinent details, yes?
That's not what I heard. Is that?
Ms. Carter?
If it's going to be under the rule that was just cited, I think that's part
Okay.
of it. 500, and then there's 3 of them, because it's like the respondent did it under their name, the firm's name, and then there's a second one under the firm's name as well. So the $1,500 for
So it's 3.
each one. That's what I see on here.
Okay, so there's 3 violations, $500 each for a total of $1,500.
Correct.
Any further discussion? Who seconded? I'm sorry. Seconded by Commissioner Moffitt. Any further discussion on the motion? Hearing none, let's vote. All those in favor of the motion, please say aye. Any opposed? Hearing none, that motion carries unanimously. Case number 96, Commissioner Smith.
My question was, I didn't understand this sentence. The next day, the complainant's agent advised that they should terminate the contract, since they would have to get a second home inspection if it went past 8 days. I didn't understand that.
I believe that they had amended the inspection period to 8 days instead of like 10.
Oh, okay.
And so if they had missed that specific time frame, they'd
Then
get it
they would have-
again. And I
Okay.
think they didn't want their buyers to deal with that.
That was fine. Okay, I just didn't understand that last sentence. Thank you.
So Council's recommendation was to issue a letter of warning.
Yes, I accept council's recommendation on number 96.
There's a motion to accept council's recommendation in case number 96. Is there a second?
Second.
Seconded by Commissioner Tucker. Any further discussion? Hearing none, all those in favor of the motion, please say aye.
Aye.
Any opposed? Hearing none, that motion carries unanimously. Case number 137, Commissioner Ramby.
My question here is a little bit more generic, and it has to do with regulation of the MLS and my understanding of that. I certainly understand the requirement that information be accurate, but we don't have jurisdiction over a particular MLS.
Yes, but we do have jurisdiction over advertising.
Okay, so if this if this piece of property was not listed, okay, sorry, I need to back up. We're starting with the assumption, the MLS. And in our case here in Nashville and most of Middle Tennessee, it is Real Tracks. That is a private organization, or maybe it's public, I don't know. But anyway, it is not a government authority. So it is an entity in itself. And members of that MLS choose to place their property in that service. But based on instructions from the client, they could choose not to put it in the MLS. So how is there a violation in this case?
Whose case is this, Ariel? Is this your, you want to give an overview of this case?
Sorry. So in this case, the complainant said that essentially that the respondent violated the ability to keep the listing accurate and essentially in a timely manner, because after they went under contract, instead of saying like from active to like under contract or something to designate that there was an agreement that was pending, it just still stayed active. The respondent stated that like although it may have said that, they weren't accepting any other offers, they weren't entertaining anything, they weren't doing anything suspicious while the parties were discussing things. And so the issue was that since it was on the MLS and it was with an active, I guess, designation on it, the reason that the recommendation was for a letter of warning was just because if you have something, keeping it current and accurate is probably important. And that's where that came from.
Okay, so you used the word advertising. We're making this an advertising
Yes.
violation.
Licensees happen to use any type of multiple listing service to advertise. And so the onus is on the licensee to maintain that information that's in that advertisement accurately. So if it's pending, if it's closed, whatever the status may be, it should be reflected in their advertising.
So Real Tracks now allows you to keep a listing active while you have a contract on it, as long as you put in the comments that there's a contract on it.
Well, that would be a part of keeping that status current. Yes. Okay. So the public would know, yes, it's under contract. However, we are still allowing showings on this property in a backup capacity.
Okay.
Okay, I have some concerns, but I'll stand down. I don't think it's worth. I understand your point. I think there could be circumstances outside the MLS where something is not changed for a variety of reasons, and it would technically violate that.
I believe there are the rules.
Advertising.
Oh, so sorry.
Go ahead.
I think the rules have an exception for that. So if it's like a third party site like Zillow or homes.com or whatever kind of third party that like they don't have direct control over, then there's like no issue with that.
Okay.
Because you don't have like direct control. But my understanding for this one was that they had the ability to change and update the listing status fairly quickly.
Okay. Well, it is made, my concerns are made better because based on the fact that the recommendation is just a letter of warning rather than a civil penalty. So based on that, I would make a motion that we accept the letter of warning.
Commissioner Empey makes the recommendation to accept council's recommendation in case number 137, seconded by Commissioner Moffitt. Any further discussion on this case? Hearing none, all those in favor of the motion, please say aye. Any opposed? Hearing none, that motion carries unanimously. Case number 138. I commend you, Ms. Carter, for untying this knot of a case with this narrative. You marked this for discussion. So what is it that you would like us to know about this case, other than what was in the narrative?
Okay, we'll try to give the like most basic summary that I can. There's a lot of like interconnected issues in this one specifically, but it boiled down to the complainant who had an interest in a property that was in a part of an estate. So it's like one of maybe like 3 sellers for an estate. Their concern was that the respondent ended up with the property buying it after the fact, and they alleged that they used the buyer as like a straw hat individual during the transaction, and basically they knew that it was going to happen, it was going to end up with them, and they had personal issues outside of this transaction. However, the respondent was not a direct party in this transaction, just kind of bought it afterwards through a quick claim deed from the buyer. So their concern was essentially how it looked and how quickly the property switched hands afterwards. My initial recommendation was for dismissal, just because it seemed like everything was done up to par as far as like the contract went. And the closing, I feel like they didn't have that much to say as far as who it gets sold to after the transaction ends. However, I knew there was like a rule about like disclosing your true purpose in a transaction. So I just wanted to put it for discussion to see if we're on the same page or not, basically.
So the respondent in this case, they claim that they were not party to this transaction.
Yes.
So are they named in any of the documents at all that were fully executed in relation to this transaction at all?
It's a second transaction. So it's like complainant, buyer one, which is like a company, and then buyer one, respondent. So it's like 2 separate ones, but sort of connected, I guess. And the buyer and the respondent knew each other and did business together as well.
Buyer one and respondent.
Buyer one and yes.
Yeah. But the seller is the complainant then?
Yes.
Okay. So.
And the property's like part of an estate. So like they weren't the only interested party, but did have a connection, and felt that there were some disclosures that needed to be made for a lot of people as far as this transaction goes, but mainly just the respondent who ended up with the property
So
eventually.
the seller feels like the respondent did some scouting for the buyer, the first buyer?
I believe that's kind of like the feeling behind it. It's
And
kind of like the buyer and the respondent knew each other. So they kind of like talked together about like buyer one was going to be the one on the deed. They're going to be the one presenting as they're going to get the property. And then after everything closed, magically the respondent has everything. So I think that was their like the complainant's assertion and concern.
Commissioners, what do we think?
This was hard to unravel, but from all appearances, the respondent is second sentence, the respondent is a real estate broker. And from all appearances, the respondent was a beneficiary after the sale, an undisclosed beneficiary, and there's all kinds of acrimony between the two, and that was hidden. Is that a decent read?
That's what the complainant would allege, yes. And the respondent's response essentially is they were only providing financial help to their friend / business partner in that, and that's why it got quick deeded to them the same day, and then they eventually transferred it back to buyer one. It was a lot going on, but essentially they're just saying like they only provided financial assistance for this transaction. That's what the respondent is saying anyway.
So the deal between the seller and buyer one, that closed. Proceeds were exchanged.
Yes.
And they walked away from the closing table with whatever money they were entitled to.
It got a little complicated because it was through the court. It was probate court, and there's like 3 or 4 interested parties, and the complainant just happened to be one of. But yes, all the money paid out, authorized by a court, and closed out, and then just same day, it was bought by the respondent. Like
separate closing.
Yes.
Outside of court.
Yes, completely outside of court.
And just between buyer one and the respondent.
Yes.
I mean, it clearly was structured. I mean, to go down like that it seems like buyer one and the respondent to me. But is it a violation of the rules? What do we think, commissioners?
Well, my personal belief is that they accepted that contract, and until it transferred later, they didn't have a complaint. So how can we hold them responsible for that?
I think sometimes we have to remember who we are. Are we ethical? We don't do ethics here.
Right.
I learned that early on. So was it ethical? Was it above board? Was it professional? Did they handle themselves well? There's not a rule against that, is it?
There's a rule about
Attorneys?
like having to disclose like your interest to a transaction, but
Yeah.
this one was just a little bit trickier just
Yeah.
because there was a lot of like exchanging of
Right.
hands, and then the property did go back to like buyer one months
Okay.
later. It got really tangled, honestly.
I mean, because,
But
your point though, Ms. Carter, about buyer one, once they closed out and it was done with court, their interest is extinguished at that point.
yes, and I think also
What happens to the
yeah,
property after that is kind of,
like
they're
an
not a
issue.
part of it anymore.
Yeah, and like also like in that consideration, it was that probate court kind of like authorized an administrator to do the sale.
Right.
So it just seemed like it was a court approved,
So,
a
and
court
the-
approved
and the-
situation. So like there's messiness, but like it
Well, and I
didn't
think
seem like it was a
that
direct.
in the narrative, I think the
insult.
complainant was saying that there was no mention of the contract being assignable, blah, blah, like all those wholesaling kind of
Yes.
trigger words that we've become familiar with. I, yeah, I don't,
I'm gonna can I make a motion?
you absolutely can make a motion.
I make a motion that we dismiss number 138.
Second.
I have a motion by Commissioner Smith to dismiss case number 138, seconded by Commissioner Gwen. Any further discussion or questions? Hearing none, all those in favor of the motion, please say aye.
Aye.
Any opposed? Hearing none, that motion carries unanimously. Case number 149, Commissioner Smith.
I pulled this one because it just looked funny to me and it felt a little awkward that money was being paid to someone through escrow. Did I read that correct?
Yes, I believe like it was been a while since we discussed this case, but to represent from
Right,
I believe
to represent.
December. But essentially, yes, that was the complaint, and the issue is that they received the money and they were trying to pay themselves, and they went and the respondent went to the bank and was like, "This person authorized me to take this amount of money
Out of the
And-
escrow.
out of the check, I guess, like once it closed, and then
So did I
we
read
had-
that,
we had
did
an
I
issue with
read
that.
that correctly? That they went to the bank to get the money and they were told that some of it was being held?
I believe that everything had closed, and then they were going to the bank to just get their portion of what was owed to them. The concern was that they're going to get money from someone else's bank account. Although they said they had authorization to do it, it just seemed weird. But I didn't get any additional information, so I couldn't give you any like specifically like which account it came from or anything like that. But
I just didn't understand the language. The respondent withheld $1,500 as a loan.
yeah, so essentially they were saying that. So this person was like, I believe it was submitted on behalf of the complainant. So it wasn't actually the complainant who was upset about the transaction. It was just someone on behalf of them.
Okay.
And they were saying like in two separate instances, like money was withheld. And then I think essentially they're saying they were pressured to give and pay the respondent the money. And the respondent was saying like everything was above board. Like they called the bank, said it was fine. And I didn't have any, like they said that like the complainant didn't have an issue. So they weren't really sure why they even had this complaint against them. Again, the concern was just like, is it a personal thing? Like, but if it's money that they had in their possession that belonged to someone else and they just didn't give it back, that's the concern for the two times that they did it.
I think when we initially heard this case or discussed this case, the issue was that there was money being held in escrow. And since it's being held in trust, that money does have to go back to the client or be dispersed in some way
Correct.
in compliance with the contract or interpled. And I guess after the money was returned back to, or dispersed in a way that needed to be dispersed, then there's this $1,500 that is cut for the respondent.
Yes, so it's like an earnest money release was signed, and I think it was like, it's supposed to go
So,
back, and it went back to the
and
account.
There was
weird.
paperwork in there where that money and this kind of transfer of it was documented and memorialized and signed.
No,
No.
it was just everything that they said, and I think because the complainant isn't the individual who wrote the checks or gave authorization in theory, they probably don't have that either.
But the client
The
that had the money, that received the escrow money, the person that received the escrow money, they willingly turned that money over to the respondent.
That's what the respondent says. So,
But the person,
but there's not but the person who actually got that earnest money, they're not the
there's no
ones who,
testimony from them.
no, they didn't present anything.
I just don't think we have anything to go on then. Because we're hearing it, I mean, it's third party, it's kind of like hearsay testimony then, wouldn't it? From this complainant?
If it went to a hearing, probably would have to get around that, yes, but essentially it's like on behalf of someone
Yeah.
involved in it, but there's nothing direct other than I guess their personal knowledge of the situation. That's the way we get that in, but the actual individual client did not present anything, and I did not see an earnest money release. And the bank, I don't think has a record of a call from someone that they remember from 2023 or.
And you don't feel
2024.
like you can go to hearing on this? The way it is right now?
The way it is right now, we can make arguments.
Well, yeah, you're attorneys. I know you can make arguments.
It would probably be a little tricky, without kind of getting more
Heavy
information,
lift
but
and
we
a
would,
waste of resources.
but we'd have more ability to kind of get documentation and subpoena things from the bank or other people,
Okay.
require them to give it, but
Is the juice worth the squeeze though?
you can tell me.
You can tell. Okay. Commissioners, what do we think? We want to chase this one down, or do we want to? How curious are you, Commissioner Smith, about how this was handled?
When I read this, it sounds like that the money went, instead of going from the escrow account, it went to an individual, and then most of it went to the person it should have gone to, but some of it went to the respondent, which doesn't feel good to me.
I think it was deposited. So I think it was the release happened. It went to the
Yeah.
bank. That check got deposited, and then they asked for money in the same transaction. That's how it was explained.
Yeah.
But I have nothing to.
Okay, the other
support or
thing that
defeat it.
concerned me is this person's license expired in November of 25. So I'm assuming, yes, all of this happened in 24.
Yes, I think this was a 2023, 2024 case. So their license would have been valid at the time. I can 2020. Let's see. I can look really quickly to see if they still have a active license right now.
This says the complainant called the bank and instructed them to release $2,500 from their account to them. And it's my understanding the bank complied, which
They did.
means they went through all the protocols they had in order to release that money.
Since it was a phone call, they don't have a record of it, but in theory, yes.
Since
Commissioners, what do we think? Is there a motion?
I make a motion that we dismiss this.
Second.
There's a motion to dismiss case number 149 made by Commissioner Tucker, seconded by Commissioner Rampy. Any further discussion? Hearing none, all those in favor of the motion, please say aye.
Aye.
Any opposed? Hearing none, that motion carries unanimously. Unless there's any other business, that concludes the legal report. Next item on the agenda is any new business. Commissioner
Just
Baker.
as
Ms. Baker.
an update, during August's meeting on August 5th, 2026, here at the Davy Crockett Tower, you all will undergo ADA training. It's American with Disabilities Act training, and how we should function as a group, as a commission, as it pertains to those with disabilities. So we'll have that training. It's about turning on mic, saying your name when you speak. And so we'll go through that training during the commission meeting in August. Also, as another update, our hearing date for October has changed. We inadvertently scheduled a hearing on a Friday. So we have changed the hearing date to a Wednesday, the day before the commission meeting on the 15th. Wait, hold on, let me make sure. One moment, let me make sure I have my dates correct. So the hearing would take place before the meeting on the 14th, if we were to have a meeting, a hearing, and then the meeting will still be Thursday, the 15th, and the hearing is no longer on a Friday, October 17th. Or October 16th. Can't get my days right. Does that make sense to everyone? Do I need to repeat that? Is it the 7th and the 8th?
So we have
October?
Trec, we have a Trec meeting October the 15th?
I misstated my dates.
Okay.
Let me go back. Thank you, Anna, for the clarification. It's always great to have good counsel. The hearing is now on Wednesday, October 7th, instead of Friday, October 9th. The commission meeting will still be held on Thursday, October 8th.
Okay.
Where
So-
is that?
Here, everything's here.
Okay.
We're changing a day.
So we're gonna have the hearing before, if there is a hearing,
So-
it would be before the commission meeting that Thursday.
Okay, so if we have a hearing, travel day is the 6th, hearing on the 7th. regular
Commission meeting on the
8th.
8th.
Okay.
That way you all can go home and enjoy the weekend without having a hearing on Friday, October 9th.
Okay. Got it.
Okay.
Is there any way to do the hearing on after lunch on the 7th?
We would have to work with the administrative law judges. I can't remember what that group is called, APD, the Administrative Professional Division, in order to change that. And we've already changed it from Friday to the Wednesday before.
It would save an overnight.
It would, but we may not have a hearing in October, so we'll know more information in September.
Do what now?
We may not have a hearing in October.
Ah,
We're just
okay.
making you aware that if there is a hearing, as of today, it would be October 7th.
At what time?
Let's say 9 o'clock. I can't recall what.
So
listed.
the reason we're not sure if it can be on after the hearing is because when we vote on the hearing dates, and the meeting dates in advance, we submit that to the Administrative Procedures Division, and they reserve judges for us on those days. So I can look and double check and make sure we have a judge reserved for the day of the meeting, but otherwise I don't know.
All I'm saying is.
I understand
Yeah.
for efficiency purposes.
Right.
I just don't know if it's possible, so I have to ask.
It's a whole different division.
Like,
Right.
we book them a year in advance, so
So what you're saying is if we have a hearing on the 8th.
I have to see if a judge is
As
available.
opposed to another time.
If we have a hearing, in order to have a hearing on the 8th, I have to see if a judge is available.
And sometimes
Got
it's an all-day hearing.
So I don't know.
No, rarely.
And those are
You
fun.
still have to spend 2 nights, Steve.
We enjoy them as well.
Uh-huh.
That's the only new business that I had.
All right, commissioners, any other business? Hearing none, we will be in recess or adjourned until the August meeting. Everybody travel safe. We are adjourned.
Thank you.